Dismissed.
Let's. May it please your lordship, in item number 41, I appear for the DRI. Here the
50?
case 41, you know.
41.
I'm appearing for the DRI. Here the case diary has not yet been received. Since the IO is actually involved in an operation in an undisclosed location. So 1 week time may be granted to case diary, your lordship.
Informed other side.
Yes, yes.
We did not receive list again on
So 1 week.
this.
Yeah, Your Lordship. My lord, this is second bail application. Earlier one was rejected by Your Lordship. In a FOXO matter, to be listed tomorrow, my lord.
Tomorrow nobody is coming.
But a court, no, that Monday, my lord.
Maybe. Item number 22, Lordship. I have taken consent from the other
20?
22, Lordship.
Huh.
Only pass over 40 days and matter may fix on 10th of August. 7th of August.
I am appearing for the respondent, my lord. So let's.
Letter of learned counsel for petitioner. Of the respondent list the matter again on
7-8.
Here is the interim order, Lordship.
May it please your lordship. Lordship, I beg to mention item number 34, regular bail, my lord. CD was called for. I have just been informed that probably, my lord, matter is charge sheeted. Lordship may kindly call for the TCR, my lord.
This matter, in this matter, I'm appearing for respondent number 2, my lord.
POCSO matter. So
Yesterday I received the notice, my lord. Today I filed the Okaluna, my lord, reconsidered it.
lordship, can it be on 7th or 11th as per lordship's convenience, my lord? Deeply obliged.
May I plead, Your Lordship? Lordship, item number 37 may be fixed on Monday, Your Lordship. Senior counsel A.S.R.S. Chaudhary is unavailable due to his illness, Your Lordship. He was receipt may be kept.
My lord, it did.
all right Monday.
May I please your Lordship. Lordship, I beg to mention item number 20 from today's list, my lord. Item number 20. Lord, here in this case, my lord, on 26/6/26, we have entered appearance on behalf of the sole respondent, my lord. Although today, when the matter is listed before the court, my lord, our names has not been reflected, my lord. So I pray before your lordship to direct the registry.
List the matter on. Is the matter showing the name of learned counsel for the respondent? Third appearance on
Deeply obliged, my lord.
Deeply. If please, your lordship, with regard to item number 13, my lord, on 3. My lord, the matter may be some personal difficulties today, my lord. It will come after 2 weeks.
all right.
On behalf of the respondent, my lord, we need an early date as it was only once listed since it's been filed.
Date will fix, no issue. Highly blessed.
May please your lordship. Lordship, I beg to mention item number 35, lordship. Bail hearing, lordship, and AB, lordship. Regarding this matter, lordship, we have the petitioner, lordship, is in a settlement process with the complainant, lordship. So matter may be listed after 2 weeks, lordship. Any date after 2 weeks.
It is available, my. Finally then, up to date CD, I will send.
Right. Right. Submitted that some settlement discussion is going on between the parties. Yeah, it has been made on behalf of the petitioner for adjournment. So, hence list the matter again on. Can beg the CD for resubmission on the next date fixed in updated form.
Deeply obliged. Lordship, today BA 1952 has been fixed with 973, lordship. BA 973, but the matter did not came, lordship. 973 came, lordship, in the supply list, lordship, but
Yeah, my lord, in item 51, 52, 50, they're all connected, my lord.
My learned friend case 1952 did that, that was not listed. It may be listed along with 4 items, may be listed item 1 yet subject to
Items?
in the supplementary list, my lord, 51, 52, therefore
51, 52.
Case number lordship.
and also my lord,
Lordship, my case number lordship BA 1952.
Yeah.
26. 1952 oblique.
All these matters on Monday. Council, what about council?
Tuesday, my lord, can
Tuesday. Inform the council.
53, my lord, he is here. 53 can be my lord.
Okay, Tuesday.
Well, on Tuesday, Lordship, deeply obliged.
Always.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 21, my lord. Now, this matter may be taken up next week, my lord.
Twenty-one.
Obliged.
That may be fixed, your lordship. That may be fixed.
Then-
Oh,
May I please your lordship? Lordship, I beg to mention item number 27. I'm appearing on behalf of OS Mandan. Kindly get the matter after 1 week, my lord.
May I please to Lordship? Lordship, item number 45, Lordship. In this matter, Lordship, service report is awarded. But my senior, Mr. A.M. Borbia out of station, Lordship. Matter may be kindly possible for the day, Lordship.
It's a 100. 100.
Yes, this is a lordship. My lord, 483 application and offence is registered under the Narcotics Act, my lord, under section 22C. So at this stage, my prayer is lordship kindly call for the TCR, my lord, and thereafter.
Scan copy of TCR.
may I please, your lordship? This is a search-seated POCSO case where the arrest is completely illegal, lordship. Firstly, lordship may kindly peruse the wakalatnama. Accused petitioner number 2 and 3, they have signed in thumb. Thumb impression is there. They never saw school in their life. And lordship, regarding 2 other petitioners, they were LP school fail. LP school dropout. Now, lordship, here, lordship may kindly peruse page number 40 onwards. These are the ground of arrest memo under section 36 BNS. From page number 40 to 63, these are the arrest memos, which are completely in English. They never understand this type of language. Now, lordship, when a bail petition has been moved before the POCSO court in North Lakhimpur, in Majuli, an order has been passed whereby bail is rejected on the ground that the IO has stated by a declaration before that court, stating that in Assamese language, IO has tried to explain the grounds of arrest. But lordship, here is a judgment. This is not enough. Lordship may kindly peruse the flag mark page, the last page of this judgment. Here, lordship, the IO has filed before the court stating that in Gujarati language, he explained the grounds of arrest, but court didn't accept it and declared it as an illegal arrest. Here is the same case, my lord. In my case, These are missing people. They have only their oral language. Missing people, they are tribal people, lordship. Even they didn't have any written language. This is a landmark judgment, lordship. Even the IO tried to express the grounds of arrest before the arrested persons. The court didn't accept it. Law is law. Here, lordship, I am totally not on merit, not on the case. I am on the ground of illegal arrest. The mandatory requirement hasn't been fulfilled and it is a complete illegal arrest, lordship.
This is an NSA case. Preventive detention case. That's
Yes.
different.
Yes, Lord.
Nothing to do with 47, 48. That is under the Preventive Detention Act that communication is to be made. You say you are illiterate.
Lordship, we are arrested under Lordship POCSO,
Yes, you are illiterate.
illiterate.
Cannot read and write.
Yes, Lordship.
Suppose it a written language in a written notice in any language is given to you. How will you read it? Tell us.
They have to elaborate the grounds of arrest
Yes, I have
in
stated
the
that.
language I could understand.
Yes, I have stated he has done it.
No, Lordship. We are missing people. And IO is not a missing lady, Lordship.
Hmm. No, he says he has explained in the language you understand.
Here is a case where Lordship, I have filed a declaration before the POCSO court
Hmm.
that I have explained the grounds of arrest in Assamese. But Lordship, we are missing people. We have no written language. We can understand only our language.
Where are you from?
Missing people, they are tribal people, Lordship. Declaration is not with me. It is.
Where are you from?
We are
Which
from
place?
Majuli. Majuli.
Hmm. Have you met any missing person from Majuli? He doesn't understand Assamese?
This is a doubtful question, Lordship, which I can't answer properly because see, whether they know Assamese properly.
Where is your statement that you do not know Assamese?
In
Anyway, it's a POCSO matter. We have to issue notice to the respondent. Yes. Give it that.
TCR, scan copy of TCR may be called.
Yes. Can copy of TCR and not.
oblige.
Your Lordship will find the FIR at page 10. The petitioner was arrested out of suspicion, Lordship, alleging that he tried to lift a dog in his vehicle. The FIR was lodged on 11/7/2026. Then preliminary inquiry was conducted on 11/7/2026. Thereafter, the FIR was received and was registered on 19/7/2026. Within that 8 days time, the police says that there is no requirement of issuing 35(3) notice. Reiterating the same grounds which are mentioned in the 35(3) that your Lordship will find in page 13.
So who is the owner of a street dog?
In fact, if your Lordship peruses page number 13, the preliminary inquiry report, it says that no one could be identified. It is revealed that two unidentified persons used a car to commit the alleged theft. However, due to poor lighting conditions, it was not possible to identify the registration number of the vehicle or the identities of the accused persons.
So where is the dog now? In your belly?
That Lordship, I do not have the information.
Dog is not recovered.
Hmm?
Dog is yet to.
What is the date of arrest?
Lordship, 19/7/2026. 12 days already in custody. In fact, the 47 notice which was served to the accused, it does not state that where the person was arrested. That is also missing in the 47 notice.
Page number 21, madam, of the earlier rejection order.
Huh? No, rejection no. It is production order. Rejection nahi. No bill application was filed, so therefore there is
That is the production order.
Production order.
Production order.
the only reason of not serving the 35(3) within the 8 days period is that he belongs to some other district. So therefore there is possibility of absconding. That cannot be a ground to not serving 35(3) notice when the offenses are below 7 years.
Clear from the case diary, madam.
That is apparent from the 35(3) notice and checklist itself, Lordship.
What is the punishment in section 11?
Lordship, fine is there, Lordship, only.
Hmm? A non-bailable offense. Only fine.
303 is there, madam. For the rest.
In the first, in the case of a first offense with fine which shall not be less than 10 rupees, but which may extend to 50 rupees. And in the case of a second or subsequent offense committed within 3 years of the previous offense, the fine which shall not be less than 25 rupees, but which may extend to 100 rupees or with imprisonment for a term which may extend to 3 months or with both. 303 is also 3 years.
So out of whose possession was it taken?
That is
To
not,
attract 303.
that is not there in the preliminary inquiry report itself.
Dog was lifted from the outside of the house, as per the appointment.
No, who has lost the FIR?
FIR was by one Pranay Das,
It says street dog. Does it have an owner?
No, it's a community dog, so
Third learned counsel for the petitioner. Learned additional PP. This is an application under so and so. The allegation as reflected in the FIR is that the petitioner on 11/7/2026 grabbed a street dog by the neck and forcibly placed it inside a four-wheeler vehicle and fled from the spot. Post of para. Although it is stated that there is CCTV footage in the with regard to the incident, is also stated in the forwarding report. And that line is not necessary. You can CCTV footage you got. The petitioner was arrested and forwarded on 19/7/2026. Since then, he has spent about 10 days in custody.
12 days, Lordship, as of
12 days in custody. Para also appears that he has already been interrogated, whereafter he was remanded to judicial custody. An additional PP submits that the dog is yet to be recovered.
Perusal of the case there is necessary.
And therefore perusal of the case diary is necessary. However, having regard to the nature of the allegation and the fact that the petitioner apparently is not required for further interrogation, the prayer for bail is allowed. No, so and so shall please on bail of ₹50,000 with 2 securities of like amount to the satisfaction testing of the learned students. Jurisdictional magistrate. Provided that the petitioner shall cooperate with the investigation in future if necessary. Also participate in the trial if one commences. According.
Obliged, Lordship.
May please, Lordship. Yes, Lordship. Then notice is only respond number 2.
PD and respond number 2.
Then TCR may be called for.
Transited.
Transited.
Only 10 copy of TCR.
Cancel this.
The petitioner already in custody for 1 month. 1 month, my lord. PC Act is all trap case basically. He is not directly involved. My lord, the short date may be given for their response, my lord. CBI's response, probably they may like to file the response.
That is the problem with CBI, short date.
Nothing, hello, already in the custody for.
Already 30 days, so file by 1 week.
Next week, twice, then, my lord, 6 months.
CD or lordship, it's
Yes.
required.
Objection.
Both, file both. What is the happen if you want to? Otherwise, give the CD at least. Yes.
Sixth. 6
Seven.
months.
May I please your lordship, kindly we make it on 7th your lordship.
বিষয় দিলা না দেখা না
Approve হয়ে আহি বলে গো।
এখানে কি একটু করলাম
নয় প্রায়
Alright, you quibble and give a date.
lordship 7th
7
Monday.
Please, your lordship. So DPS case, your lordship, will call for the case diary. Again, my lord, even after 2 years, non-compliance of 47%.
Earlier rejected, no.
No, my lord, first time. Short date, my lord. Program. 47. It will be too long, my lord. Apparently, my lord, non-compliance, my lord.
17.
12.
Okay, my-
It's up to- Deeply obliged.
Please, your lordship, my lords, NDPS matter, my lord. Similar bail application, my lord has fixed on 13th of August. BA
Yes, along with-
746 of 26.
Is along with so and so on. 30th.
746 of 26. Out of same PS case. Thirteen eight. All right.
May I please lordship? Regular bail application lordship, POXO matter. FIR is page 8 lordship.
Let's CD.
CD and notice, my lord.
NDPS my lord, CD by me.
Same only. CD only.
18 or 20. Zero. Obliged.
My pleasure. This is received bail application, my lord. The FIR at page, my lord, 10, my lord. And the driver and the owner of the vehicle has already granted bail by this honorable court, my lord. That is page 16, my lord. It is in respect of, my lord, the owner of the vehicle. My lord, he is the owner of the vehicle. And page 18, he is the driver, my lord. And the present petitioner is the, my lord, brother of the, my lord, owner of the, my lord, registered owner of the vehicle. Is no involvement in this case.
Regular bail.
No, my lord, it is undisputed bail.
Which one? Page 16 is regular bail.
No, my lord, AB, my lord.
Maybe.
AB 429, my lord.
Who are you? Owner.
No, my lord, he was the owner. The petitioner was the owner.
That was owner.
Owner.
No.
And my lord, page 18, he is the, my lord, driver. Page 19, my lord, he submitted the petitioner that the driver of the vehicle. And I am the, my lord, brother of the, my lord, owner of the vehicle, my lord, and no involved in this case, my lord. However, my lord, the police is searching me. I will appear before the IO, my lord, and cooperating, my lord, the investigation.
কি notice এইটো? Oh, notice. Next. My lord, their petition reflects, my lord, at para 7, my lord.
My lord,
Only thing, my lord, he is the brother.
I am
And
the
there is no
brother.
apprehension as such, my lord, if he is only the brother,
Brother of?
brother of the owner
Owner
of
of
the
the, my
vehicle.
lord, vehicle.
Perhaps he may be the main person, my lord, who is running the business, my lord. That is why owner was granted, he is not, now he is coming, my lord. That might be also a case, my lord.
Is the driver and owner of the, my lord, vehicle has already granted bail, my lord. I will, my lord, appear before the IO. In cooperating the investigation, my lord.
He is the registered owner and he was not aware of any cattle theft. That is the, my lord, submission in the earlier order, my lord.
Here it is that depart says the aforesaid cattle with valid documents.
He says the
Yes,
Where is the valid document?
my lord, that Jamal Basha, my lord, he purchased, my lord, the,
Yes, he is your brother.
my lord.
So you could have shown the valid documents.
But in fact, my lord, it is not, my lord, stolen, my lord, cattle, my lord. It was purchased, my lord, from the market.
So what
And it was-
prevented you from annexing the documents?
Lordship, my lord, in the village market, my lord,
What?
in the village market, my lord, some, my lord, receipts was issued. My lord, sometime it was not issued. But, my lord,
Said it is purchased with valid documents. It is your statement. Then
I have not, my lord, not, my lord, here, as per his statement, my lord, Jamal Basha has, my lord, purchased that, my lord, cattle.
that is what we are saying. He is on bail. He is your brother.
Yeah.
So why don't you have the documents? It is you who said he purchased it with valid documents.
And, my lord, the offense, my lord,
So where are the documents?
the offense under section 302, my lord, is, my lord, theft, my lord, punishment of theft. And, my lord, section, my lord, 13(1) of the Assam Cattle Preservation Act. This, my lord, punishment is 3 years and may extend to 8 years. And, my lord, section 11(1)(d) of the Prevention of Cruelty, it is only fine. So, my lord, I may be granted bail, my lord, the quorum, CD may be called for bail.
There is probably material against you, that is why you have come.
Maybe, my lord, but I am not
There is-
denying at this stage, my lord, because maybe, my lord, but.
So if you are not denying, we'll have to wait for
But
the CD. Why should
that-
we grant you
If that
interim?
be so, my lord, as per statement of the, my lord, co-accused. Because if the petitioner is not named, my lord. Maybe, my lord, as per statement of the co-accused, my lord.
Now we have a decision which says that statement of the co-accused can also be
Maybe, my
taken
lord,
into
because, my lord,
consideration. Okay, fix a date for CD. Sorted.
and my lord, I'm, my lord, to cooperate in the investigation, my lord. Interim maybe.
Births of radio. 14 year, 14, 1, 4.
Yes.
Interim, my lord, I am very familiar to interim.
What is the date of occurrence?
My lord, it was, my lord,
On 2-1, my
two
lord.
or, my lord.
2-1-26, January.
2-1.
26.
You have waited from January and
No.
now you are in a hurry for interim. Yes.
My lord, I don't know, my lord, why, my lord, police is charging me, my lord.
Next.
Plus.
Lordship, this is a pre-arrest bail application, Lordship. POCSO matter. There is also
Section
sections. Lordship,
2
6 and 7, Lordship.
CD. Notice to respondent number 1. Number 2.
Right, Lordship.
Next, please, Lordship. Lordship, I'm for the respondent to appearing on behalf of my senior RCC, my lord. My lord, he's not well, my lord. He also got the injury in the right face, my lord. So, my lord, can this
You are
matter
for
be taken up in-
respondent.
I'm for the respondent too, my lord. He's in the High Court, but he's not well, my lord. So, I'm praying this matter may be fixed on in the next week, my lord. Anything in the next week, my lord.
Who is in the High Court? Who is in the High Court?
My senior is in the High Court, but he's not well, my lord. He come today, my lord, but he's ill, my lord. He's also got the injury in the head, my lord. Saying this matter may be fixed in the next week, my lord. So,
Your respondent number?
2, my lord.
So you have got the notice. Last order says no notice. None appears for the petitioner. Learned counsel have entered appearance for the respondent number 2. Is the matter again on interim order passed earlier shall continue till the next date of listing.
Kindly pass over the matter for timely, Mr. R days on legs.
Timely.
I please, your lordship. Lord, your proceeding of the trial court is challenged, your lordship. Your respondent number 2 is the victim, a victim's father, your lordship. They have filed their affidavit also. FIR at page 15, your lordship. Ideal case, your lordship. Page 15 is the FIR. But after such fateful incident, Your Lordship, there was village meeting, Your Lordship. Page
What is
6,
your name?
Abdul Salam.
Charge sheet is against what?
Abdul Salam,
Abdul Salam.
my lord.
And who are the other two? Syed Ali and Nasir
Syed-
Hussain.
Syed Ali is the father of Abdul Salam, and Nasir Hussain was the father of victim, Your Lordship.
Yes, so
With the allegation of a child marriage, my lord, against them. But after such incident of suicidal, my lord, one village meeting was held, page 16, Your Lordship. At the village meeting, my lord, the father of the victim executed one affidavit. During the course of investigation, my lord, this affidavit was submitted to the investigating officer. Nothing has been stated in the charge sheet regarding this affidavit, Your Lordship.
yes, you have submitted affidavit. Yes, PP, anything?
Right, my lord. And beside case on compoundable, my lord, as far as though, my lord, the file, my lord, a law take its own course, my lord. The date, my lord, the FIR filed. Stated that they will withdraw. So not withdrawn the FIR or anything, my lord, yes.
No, this is not a case. Question of compounding, they have come for quashing.
Fucking, my lord.
Have you gone through PCR? Any decision of the Supreme Court? No.
Today I have not brought it.
Huh? You want us to do your work for you?
I will submit later.
Hmm? There are decisions of this court also.
Man.
You are not willing to do the hard work. Why should we indulge you?
I will provide it.
Prayer of learned counsel for the petitioner is the matter again after 2 weeks. Enable petitioner to place certain decisions of the certain decisions.
May it please to your lordship. Lordship, in this case, Mr. A.K. Gupta is supposed to be appear. He has some difficulty today. Kindly matter may adjourn.
My lord, I have entered into appearance on behalf of the sole respondent, my lord. I have not received any notice, my lord. Just upon coming to know regarding pendency of this case, my lord, I have filed my wakalatnama. They may be directed to furnish a copy to me, my lord, so that on the next day I can file my affidavit in opposition, my lord.
Learned counsel for the petitioner. You are Mr.
P. Jain. P. Jain, my lord.
P. Jain, learned counsel enters appearance for the sole respondent.
Sole respondent, my lord.
Copy of petition be served upon him during the course of the day. List the matter again on.
My lord, there is one small prayer, my lord. One more criminal petition is filed by them between the same parties, which is criminal petition 719. That may also be tagged with this, my lord. Kindly.
Is any date is fixed in that case?
My lord, date is not fixed, my lord.
The matter again on along with
Criminal petition 71925.
interim order if any stands. Interim order if any stands extended till the next date of listing.
Lordship. Lordship, we will furnish copy within 2 days. Lordship, we do not have copy right now.
All right, within 2 days.
I'm deeply.
Obliged.
This is a criminal revision petition, which has been preferred challenging the judgment and order dated 7/11/2025, passed by the learned principal judge, family court number 3, lordship. Thereby, court has directed to pay 9,000 per month as maintenance to the respondent. Should the marriage between the
Counsel for respondent, name is shown.
They have filed your wakalat, your lordship.
Do, none has appeared. You are having an interim order.
Yes, lordship, I'm on in.
Learned counsel for the petitioner, none appears for the respondents, although names of learned counsel are shown in the cause list. Again on after 2 weeks. Interim order passed earlier to continue till the next date of listing.
Deeply.
Right, please, your lordship. We've entered appearance for respondent 2 and 3. We'll need some time to prepare the case and procure some documents.
May I please, your lordship? Lordship, the petitioner herein is aggrieved by the order dated 6/3/2026, lordship, before the Chief Judicial Magistrate Kamrup in CR case number 201 of 25, and is aggrieved by the dismissal of the Naraji petition filed against the final report dated 9/10/2024. Lordship, herein
So what is to be done now?
the
Your
records are to
petition
be
is
called for.
dismissed. Yes, already called for. Third learned counsel for the petitioner. Mr. You are?
R. Ghosh.
Enters appearance for respondents number
2 and 3.
and 3 and prays for some time to
Lordship, may call for the records kindly.
documents. Is allowed to list the matter again on
Obliged.
September. TCR. Reminder for the TCR. Scan copy of the TCR.
May I please, your lordship? But in this case, we have challenges the learned trial court's order dated, my lord, C6/25, whereby issued NBW, my lord. Before issuing NBW, my lord, learned court, trial court issued summon to the accused persons, and after issuing summon, by observation that summon though served, but not appeared without any reason, issued NBW, my lord. But before issuing NBW, my lord, available warrant of arrest not issued, my lord, directly issued NBW. In this case, my lord, present petitioners are also not the prime accused. Main accused was the Gautam Mandal, alias Bishal, who has already released on bail, regular bail, my lord. And along with other 2 accused also granted bail, my lord, by this honorable court. My lord, I am praying for, my lord, some protection may be given, my lord. They will appear before the trial court, my lord, each and every day and face the trial, my lord. FIR at page 24, my lord. Impugn order is page 41. Subsequently, PRA also issued, my lord. Fight 1725 order. Second impugn order, annexure 6, page 42.
I have annexed my lord summon service report at page 75. Someone also not served my lord, directly my lord, to the family member. Some relatives of same village, not directly to the house of the accused my lord.
Page?
Page 75 is the summon service report is page 76. One auntie. Then another summon service report is at page 79, annexure 8. And page 82. 3 service report is there.
Who is this Giribala Mandal? Your auntie?
Auntie, my lord, but who is not residing with my house, this present accused house. Page 14, para 14, I have stated this statement regarding service of summon. Para 14 of my petition. One accused Shankar Mandal, who is a resident of my lord, village Purba Domgao district Sirang, but is summoned served on at my lord Lalmati, Abhayapuri district Boingao. Originally, he is resident of Sirang district.
Yes.
Appearing on behalf of respondent number 2, Lordship, as amicus curiae. First submission is this against the impugn order, revision lies, Lordship.
Notice this. Where have you come with a criminal petition? What for? What is your prayer?
My lord.
Secondly, Lordship, notice was duly served, Lordship. After receiving of notice, they have not appeared, Lordship.
I'm praying for my lord, set aside the only NBW order, my lord.
Then?
And
Then you
NBW
should
and
have come
PN
by way of revision.
Alternative provision is there.
When specific provision is there, how can you come under 482? Your ground is that you were not properly served summons.
Yes.
And the order is therefore illegal. Then revision lies. Should have come in revision.
I may be allowed to file amendment, my lord.
Is there any provision for amending a criminal petition into a criminal revision? You have to withdraw and file again.
Then my lord, I'll file. Then I'll file my lord, fresh criminal division, my lord, and with liberty to withdraw.
Learned counsel for the petitioner seeks withdraw the present criminal petition with liberty to file appropriate petition challenging the order of the learned court below issuing NBWA against the petitioners
And PN also, yeah.
and PNA against the petitioners. Prayer is allowed. Dismissed on withdrawal with liberty.
Also speaks otherwise, my lord. Records also speaks otherwise, my lord. But submission has been made by Shankar Mandal. His PNA has been executed, my lord. Another 2%, my lord, they file petition for appearance, my lord. So well aware, my lord. Aware, my lord. It cannot.
No, even if they have become aware, there is pending NBWA against them, so they definitely apprehend arrest.
NBW issued without issuing executing the summon. His case is
No, he says case is someone is issued to a given to a wrong person.
they plead for time, man.
After that, they have come.
Yes, but that is that down goes, man.
All right. He can change his strategy now.
Otherwise, again, he will come nothing.
I'm obliged, my lord. Deeply obliged.
Thank you.
May it please your lordship. Lordship, this is a regular bail application, lordship. Today, 95 days in jail custody, lordship. Charge sheeted case, lordship. FIR, lordship, will find on page 13, lordship. Initially, case was registered under section, lordship, 140 subsection 3. That is, lordship, kidnapping and confining, lordship. And 3 and 5 of the BNS, lordship. Thereafter, lordship, subsequently, they added the section, lordship, POCSO, lordship. Accordingly, lordship, notice has been issued to the informant, lordship.
You are appearing.
I'm appearing wrong. Common.
There are two petitioners before this court, lordship. The petitioner number 1 had a relation with this with that girl, lordship. Girl already been handed over to her parents, lordship. That order reflected on page 27, lordship. A statement already been recorded, lordship. Section 183, lordship.
What about trial? Has it commenced?
Yes, for consideration of search on 3rd of August.
Clearly implicated you.
The 2-person,
Gang rape. You've seen the 183, you must have.
I have not gone through the record, lordship.
These have been furnished to you. Otherwise, case is at the stage of charge hearing now.
The client has not supplied that copy to me, lordship.
To read it, your voice will become even lower. Learned counsel for the petitioner and learned it. So and so. Petition against the present petitioners. Gang rape stroke. Aggravated penetrative sexual assault upon a minor girl aged about 4. The case has been charge sheeted now at the stage of consideration of charge. Available in the statement of the victim before the magistrate. The prayer for bail stands rejected at this stage.
Lordship, instead of rejecting, let the case be fixed after lordship framing of the charges, lordship.
Not the practice here.
Highly obliged.
May I please? My lord, this is regular bail application, my lord. I am behind the bar since 82 days, my lord. The FIR is at page number 9, my lord.
My lord, case diary not received, my lord.
Last few minutes, diary was available, my lord.
What is this, POCSO?
POCSO, my lord.
The up-to-date CD was called from, my lord. That is why we have returned the case diary.
Up-to-date CD not received. List again on. So, up-to-date CD be produced on the next date. Fixed.
I am appearing for respondent number 2, my lord.
So and so enters the appearance for respondent number 2.
Alia.
May it please your lordship. Here, my lord, on the last occasion, my lord, the case diary was called for, but instead of that, my lord, the learned PPS submitted, charge sheet has been submitted, now TCR has been called for, my lord. Here, my lord, the FIR is at page 12. Allegation is that, my lord, some persons, my lord, they were engaged in, my lord, manufacturing of fake currency notes. But from the seizure list, my lord, what were recovered from them were some few papers, black papers and white paper, and some black ink, my lord. And they are in custody. This petitioner is in custody since last 71 days. 71 days, my lord. And seizure list, my lord, only my lord, some my lord, black paper, some my lord, some papers and ink, except there are no currency, nothing has been recovered from them. Page 12 is the FIR.
The charge sheet.
My lord.
Charge sheet is there.
The charge sheet submitted on, my lord, 21.
No, but I cannot find the charge sheet.
My lord, that is, my lord, I have perused the scan copy, my lord. Only the TCR, scan copy of the TCR has been forwarded. But the scan copy of CD is not along with the scan copy of the TCR.
Even if it is TCR, the charge sheet should be there at least.
Charge sheet should be there, man.
Because seizure list, nothing is there. So,
And moreover, 71 days in custody and my lord.
what reason he is affected?
Moreover, on humanitarian grounds, on this area, my lord, is totally flooded. His family is under flood now, my lord. Sagar. Right. There go. Write out it is case to it.
Is it rejected by session judge?
There's a rejected thing.
The session judge has also called for the record.
No, 19. No, but there are other persons, my lord. There are other persons also. Other persons also. Full photo.
The forwarding report is there.
My lord, yes, my lord. For forwarding report, page 15.
Heard learned counsel for the petitioner and learned additional PP decision application under so and so. The allegations against the present petitioners briefly put that in course of a NACA checking conducted on 21/05/26 at Penny Godam near Sonari police station. Police intercepted a vehicle in which the petitioners were. How many petitioners?
Only one, here only one.
Which the petitioner was traveling. And after interception, certain articles were recovered which were suspected to be used for making fake Indian currency notes. Full stop. Upon interrogation, the apprehended persons failed to give satisfactory explanation regarding the recovered items. Full stop. Accordingly, the petitioner along with other accused persons were arrested the same day. A perusal of the seizure list showed that no fake Indian currency note was recovered from the possession of the petitioners. And in the meantime, petitioner has spent how many
71 days.
71 days behind bars. Case has already been charge sheeted. Having regard to the above, further detention of the petitioner is considered necessary accordingly. Prayer for bail is allowed. 50,000 to sureties.
CGM's all right, Oman.
My opposition,
CGM's all right.
my opposition may be excluded.
All right, only.
Objection to readable, I mean, addition. Additional with the objection to readable.
May I please your lordship? Lordship, service is awaited in this matter. It's related to POCSO matter, my lordship. The office note reflects that the service is awaited. We have taken steps, my lordship.
Scan copy of TCR has been received, but service on respondent number 2 is not yet complete. Have its service list again on.
My lordship, highly object.
Number 28, my lord, search is submitted.
Direction may be given, lordship, we will approach trial court.
And counsel for the petitioner submits that in view of the charge sheet having been submitted, the petitioner shall appear before the learned trial court and apply for regular bail. You are already in jail.
Yes, lordship.
Appear to continue, apply for regular bail before the learned trial court. Accordingly, the instant bail application stands closed.
Seat number 290 of 2026, 2026, dated 29/7/2026.
Let's.
Is your lordship, my lord. This is a Cadillac case, my lord. 483 application, my lord. 23 days in detention. Arrested on 8/7. You know, both the petitioners are the driver and the helper of the vehicle, from which, my lord, 4 cattle were recovered, my lord. 303317 and 13 of the Assam Preservation Cattle Act, my lord. FIR, my lord, page number 19, my lord.
Yes, PP.
Those were apprehended along with 4 numbers of cattle, my lord, which were carried in a very cruel manner, my lord. Inside a Bolero vehicle, my lord, 2 cattle in the dicky, my lord, and 2 numbers of cattle in the middle seat of the vehicle, my lord. While, my lord, they were apprehended, my lord, they could not produce any document, my lord.
Lord, may I submit, my lord? My lord, the owner is someone else, which is recorded in the forwarding report, my lord. Someone, my lord, may I take your lordship through page number, the second forwarding report, my lord. They were sent to 2 days of police custody, where, my lord, they were physically assaulted, which is also recorded in the order that they had injury mark in their legs, my lord. Lord, based on the length of the detention, my lord, and everything has been recovered, which is also recorded in the order of the learned trial court, my lord.
But on the same day, my lord, 4 numbers of cattle intercepted, my lord, but they could not produce any document, my lord. For that part, my lord, investigation is pending.
What is the length?
My lord, 23 days, my lord.
Not sufficient.
My lord?
Not sufficient.
My lord, may I take your lordship through page number 30, my lord, the second forwarding report, my lord. Page number 31, my lord. Page number 31, my lord, this is the second forwarding report after 2 days of police custody. This is the police gave the forwarding report. May I read, my lord? It says the release of the accused person at this stage is likely to alert the absconding accused and other members of the organized network, thereby frustrating further investigation. My lord, it does not take their release to, my lord, alert the other accused if there are, my lord. They will, anyway, they will know, my lord, that these two helper and driver have been arrested. So, my lord, the next ground says there is every likelihood that the accused person, if enlarged on, may abscond, tamper with the documentary and electronic evidence, influence witnesses, and obstruct the fair course of investigation. My lord, any condition may be imposed, and because, my lord, the mobile phone, everything has been seized, which is recorded in the court order. So, my lord, there is no chance, there is no opportunity that they can tamper with the evidence, my lord. And they are not the owner of the cattle, my lord. They are only the driver and the helper, my lord. Based on this ground, because this ground doesn't stand, my lord. This is why they have objected to the bail.
That is their objection. We have our own objections.
My lord, based on length of detention, my lord, any condition may be imposed.
Length of detention is good for bicycle.
My lord.
This length of detention is good for theft of a bicycle.
But there is no theft, my lord. Within the same district they were transporting.
You are cruel people. Taking all those cows, binding them with plastic, mouth and everything, thrusting them in the backside of a bolero. Are you human beings? You are worse than animals.
An allegation, my lord.
What allegation? You were caught red-handed in the presence of witnesses. Third learned counsel for the petitioner, learned additional PP, is an application under so and so. The allegations against the present petitioners is that they were the drivers and helper of a bolero vehicle and they were caught red-handed while illegally transporting 4 numbers of cows which were tied and kept inside the bolero vehicle in a very cruel manner. Full stop. Where the material available in the CD also clearly implicates the petitioners having regard to the nature of the allegations as well as the material available in the CD. The prayer for bail stands rejected at this stage.
Right, lord.
Wait, Lordship, my lord. Here, my lord, there are serious allegations against the additional SP, my lord, who has been pursuing her or blood. The background I have given in the case. What do you mean? This is Dhakajuli case number, my lord. Where charge is that? Sorry, Saidwar PS case number, my lord, where charge sheet is so-called charge sheet is filed. What even here? One Jadab Khetri was caught with 80 kilo of ganja in his Maruti van on 19/3/2026. You will also kindly note the date. And this prisoner was in jail for reason of his extensive wife's FIR, one after another, arrested on 28/4/2026. After 1 month, 12 days, he was soon arrested in Saidwar drugs case. He was in jail. There is no compliance to the provisions of protective provisions of the NDPS Act was done. Nothing was informed to him. And he was soon arrested and he is in jail. In the meantime, they have filed charge sheet. Now the additional SP, the election goes, we have also approached the SP. His main crime was, my lord, when he was harassed time and again, but last more than 4 or 5 months. he filed a complaint against her in the office of the SP, seeking reason why he was time and again arrested and put behind the bars. He is a MA in psychology. He was also in the mental hospital as a employee, Tezpur. He was also in Air Force Station as a guide.
Apparently, the psychology degree did not help you in your marriage.
Because only thing is that I hail from very poor family, my lord, a farmer family, and she is a school teacher with a solvent family, and there was a tussle after the marriage, and within 1 year she left the house in 2024, and after leaving the house, after a long time after, she filed a case, FIR murder under section 498A, which is not really applicable. Then also this police officer got him arrested. Even she threatened the OC also to put him behind the bars. And now also, even after complaint to Human Rights Commission and Police Accounting Commission, she has been threatening us, his family members, that I will destroy you and other things. Then a complaint went to Chief Minister also against her, misusing police power or some other reasons. And after 1 month, 4 months, he is implicated in this case, saying he is a kingpin. Then another case is Dekazuli, that also have been next, which is the next item. And in Dekazuli case, there is no name in the FIR also. Here also there was no name in the FIR. Jadab Khetri, he was the main person from whose possession the ganja was seized. From 29 of April, he is one arrested. More than 3 months now. So your lordship had call for the scanning copy of the
Item number 30, lordship. Item number 30, in page number 28, that is the charge sheet submitted, lordship. I will reveal few lines, lordship, read few lines.
20?
28. Page 28, lordship. As lordship already knows that it is the contraband items has been 82 kg.
Yes.
82.79 kgs, lordship, of ganjas, though it has been found in possession of Yadav Chetri, 28, in the middle, lordship. During interrogation, the accused Yadav revealed that he has involved in the drugs business, a peddling business from a long period of time, and he used to procure NDPS substance, ganja, from a person, namely so-and-so, lordship, of Arunachal Pradesh, and deliver the same to various persons such as so-and-so, lordship, and the present petitioner, lordship. He is the buyer. Then, lordship, if I look into the page 29, and this is a commercial quantity, lordship, so section 37 will evenly attracted, lordship, and it is also stated that in Dhekazuli PS case 94/2026 under section 20B, that is intermediate quantity is there, and that is the second item, lordship, 31. And in that 31, lordship, I have seen that also 10.379 kg of ganjas. Charge sheet also has been submitted in this case.
In the Jajwar case.
But in that case, charge sheet has been submitted and cognizance has also been taken on 22/6/2026. So how he can prove his innocence, lordship? As per 37 is there, embargo is there, lordship. It is proof. Is a similar, lordship, that is a intermediate quantity, this is commercial quantity. And moreover, in item 30, lordship, page number 117, 48 is there, lordship. His name is Dipu Kumar Bhagat, and it is given to Ram Shankar Bhagat. Signature of the informed person is there. It is also informed. In page 117.
That is all right. Now, what is the material on the against him? That is the question.
Material is that, Lordship. He is.
Statement of co-accused,
Lordship.
nothing else.
Lordship. But section 37 will be attracted, Lordship.
How?
Because Lordship, I have seen the scan copy. I have not found.
37 may be attracted,
Lordship.
but he will meet the criteria of 37.
But Lordship, I want to point out one thing, Lordship. I have only in the scan copy, I have not have the full access to the CD, Lordship. CDR may be there, I don't know, Lordship. Only the few statements are there, and the search sheet I have found. And in the search sheet, I have found this rule, Lordship.
That is what, if there is anything, it should be mentioned in the charge sheet.
Lordship. Otherwise, it is not mentioned. Whether CDR is there or not, I don't know, Lordship. And what other materials are there?
If CDR is there, that would also be mentioned in the charge sheet.
Lordship.
So 1 month, 12 days, they found Jadhav Chetri telling my name. Yes, yes, so. But they were doing so long. Why Jadhav Chetri did not tell them the name, my name, if I was the purchaser or consumer? In Dekajul case, I was not there. Two other boys were arrested. They have also been given bail. In that case also, my lord, the seizure was made in the second case, Dekajul case, on 12/4/2026. And forwarding report is given 12/5/2026 after 1 month. And then my name was included after 1 month. Totally an afterthought. There is a saying, my lord, that police can do everything except making a man a woman and woman a man.
That is also possible now.
Everything is possible. No, it was not recovered for, neither recovered for my position, nothing.
Accuser.
Originally, this Jadhav Chetri was arrested.
Yes. On 19/3/2026.
Yes.
And
19/3/26 FIR
yes. And
says,
my
during
name was-
interrogation, it was learned that apprehended person Jadhav Chetri has procured the NDPS substance from so-and-so Wangchu located in so-and-so Arunachal, was about to deliver possession to a person named Horen Keot of so-and-so village near Tezpur. No mention of present petitioner.
98 plus. Male or 29. 28, sorry, Lordship. 28.
But 28.
There it is stated 28 page, Lordship. The petition.
That is the charge sheet.
The charge sheet it is there.
So one way, that is, on what basis does he say? If he had stated that name on, he would have mentioned, it would have been mentioned there itself. He states the name of some other person, some Horen Keot. If he had mentioned about him, why his name is not there in the charge sheet? That itself makes the entire case suspicious. Heard Mr. R.P. Sharma, learned senior counsel for the petitioner. And learned the DP. This is an application under so and so. As per the FIR, one Jadhav Chetri was apprehended on
19/3/2026.
19/3/2026 at which place?
Saridwar, madam.
Huh? At
Saridwar near Thane.
Saridwar. Tezpur. While transporting a huge quantity of
82
ganja,
kilos.
he was accordingly apprehended. It appears that the present appears from the charge sheet that the present petitioner has been arrested on the basis of statement of the aforesaid accused, co-accused.
Was arrested on 28/4,
Full stop.
29.
A perusal of the FIR dated 19/3/26 shows that the apprehended accused Jadab Chetri had named one Horen Keot as the intended recipient of the contraband, and the name of the petitioner does not find mention therein. Para. From the above, it appears that there is no material as such other than the alleged statement of the co-accused to implicate the petitioner, who has been behind bars since 29
4 2026
or 26. In view of the decision of the Honorable Apex Court in P. Krishna Mohan Reddy versus State of Andhra Pradesh. And so the statement of the co-accused cannot be taken into consideration. Deciding bail application. Having regard to the above, the prayer for bail is allowed. And so shall be. Before that, after P. Krishna Mohan Reddy, consequently, there appears to be no material on the which no material, consequently, the material available are such as would lead the court to believe that the petitioner may not be guilty of the alleged offense. And further, there is no material to suggest that he shall involve himself in similar offenses if released on bail. Consequently, the prayer for bail is allowed. 50,000 to sureties. Shall not regularly participate in the trial if one commences, shall not try to influence the witnesses in any manner. And dispose.
What's my objection? Objection on the ground of 37 and that he has a previous antecedent of casually PS 94 lots.
Additional PP. Objects to the prayer for bail. Section 37 is of the NDPS Act is attracted in the present case, as well as in view of his view of Dhekiyazuli PS case.
PS case 94 or stroke 2026 lot 3.
Wherein the present petitioner has been implicated. Second case to next item to same order 37 or 37 to continue. Case number 2 8 this one. Present case to 8 case on 2.
In second case, my lord, the FIR is the arrest of two boys with the 10 kilo of gaza. He is on 12/4/2026. And my name was shown, my lord, shown arrested on 12/5 after 1 month. There also, same game play.
In the second lordship 31, my only that the case number will be this one. Sorry, dear lord. 437 will be not there in 31.
32.
This boxo is there, service not completed lot. Office lot is 29/7/2026.
My lord, petitioner is behind the bar, my lord, 234 days, my lord. Short date may be given, my lord.
You have taken steps to
My
PP
lord,
office.
My lord.
Notice to respondent number 2 is not yet complete. And copy of TCR has been received. Await service of on respondent number 2. List again on.
Short date may be given, my lord. Oh, bless me.
Please, your lordship. Today, lordship is the 47 days in custody, lordship will make kindly see.
She did not receive and IO had made a prayer for another date, lordship.
About 47 days in custody, lordship, and I have been arrested and detained, produced before the Alaka magistrate after 24 hours, lordship.
What is the allegation?
Allegation is, lordship, against me, there is no allegation. I am not an FIR named accused, lordship. Allegation, basic allegation is.
Where is FIR?
Page 15, lordship, may kindly find. Basic allegation, lordship, one FIR has been lodged by one Mahesh Kumar, lordship, alleging inter alia that his brother Moon Kumar has been missing from Rongia, the railway station, lordship. Now, two person, Mir Hussain and Sukar and Akram Ali, has taken him to Rongia station, and from there he is missing. Now, what has actually happened, lordship? This Moon Kumar, lordship, he has approached us. I am a manager at a pantry car, lordship, in the Bangalore bound Gauhati Bangalore Express. So he approached me for a job. He said that he want a job. He approached me for a job, lordship, and begging that his condition is not so good, so he wanted a job. So I have given him a job, lordship. May kindly find in page number 4 and 5. My entire thing is written down, lordship. There, 3% they boarded the train, lordship. Mir Hussain, Akram Ali, and the person Moon Kumar. Then later on in the night, Moon Kumar, he was intoxicated and he created some notions in the train. And I went to after my duty, lordship, I went to sleep. When I woke up from the sleep next morning, I came to know that he has already deboarded the train. And when I reached Rongia, lordship, may kindly see, it is annexure 3, page number 22, lordship. When I was returning back from Bangalore, I reached Rongia at around 2:20 on 13/6. I was taken into custody. And thereafter on 14/6, lordship, at a late night, I was produced before the court and arrested. Lordship, in this regard, there is one judgment of this honorable court, lordship. I want to rely upon that particular judgment. If your lordship may kindly have a look, lordship.
That person is not yet recovered.
Person, no. Person has been. 2% has been already enlarged on bail, lordship, by the court below. But that Moon, I think he has not been recovered. I am relying upon one judgment of this honorable High Court, lordship, of this bench itself. 80. Regarding the 24 hours, lordship. Sanjay Dohani. Lordship's judgment. Here also, lordship, the same thing has happened with me, lordship, may kindly see. Lordship's judgment in page number 13, 14, 15, page 8. Paragraph number 13, 14, 15, page 8 is clearly covering myself, lordship.
Yes, but yes, your ground is regarding delayed production.
Lordship.
So
Lordship, may kindly see, I have given the train schedule, Lordship, it is there in page number 22, Lordship, may kindly see. This train has reached Rongia at around 2:20 AM on 13/6. And I was formally shown arrested on 14/6 at around 12 AM. That is from the 12 PM. That is from the forwarding I am saying, Lordship. And on 14/6 at a later hour, I was produced before the court below, before the Alaka magistrate. After around more than 24 hours. I am having 47 notice, Lordship. That shows the time of arrest, formal arrest at 12 PM. This is the 47 notice, Lordship. Time of arrest is showing as 12 PM. There is two petitioner, Lordship. I am the manager in the pantry car, petitioner number 1. Petitioner number 2 is the assistant manager in the pantry car. We were not named in the FIR, Lordship. The FIR named accused has already been enlarged on bail, Lordship. Bail দিয়েছে তার FIR named accused ছিল না। Afterwards, and Tawfiqul Haq. Not FIR named. They are also not FIR named. Hussein, Afterwards is FIR named.
According reports, it does not say when they were apprehended.
Yes. That is true. But Lordship, our instruction goes the moment it has reached the Rongia station, they were apprehended. When this train was returning from Bangalore to Gauhati, Lordship, at Rongia, they were apprehended, and as per the train
This
schedule,
record is
Lordship,
there.
No, Lordship, CD is not available. Wait for another date, Lordship. Page number 18, Lordship, there is stated that accused person further disclosed that the victim was allegedly assaulted by pantry car manager.
We have seen all that. We
That
just
is
want
the
to find out what is the time of arrest. They were produced when? Where is the first order of remand? That is page 23.
Defined annexure number 5, Lordship. 14/6 they were produced. Annexure number 5, page number 24, Lordship.
CD is in additional session just court, Lordship. CD is in an additional session just court, Rongia. It is because of that CD is not available, Lordship.
This is an individual question.
PM means what? Night or day?
12 PM is day. Afternoon, Lordship. Afternoon. Has to be afternoon. Because at night it will be 12 AM. AM. Night it will be 12 AM, Lordship. It is in.
So it's at 12 noon or 12 midnight.
12:1 will be, Lordship, 12.1. 12.1 will be AM.
Yes. What will be 12?
Well, it is. 12 we say o'clock. 12 o'clock. 12
In the
o'clock.
afternoon.
12
It
o'clock.
will be midnight definitely because they were produced on 14. So from this we cannot say it's 24 hours.
12 PM, 12 PM is afternoon, Lordship. Because, Lordship, why I'm saying 12 PM is afternoon, Lordship? I was arrested on two.
All right, you said 12 PM is afternoon. They were arrested 12
They were
in
arrested on-
12 PM afternoon of 14/6/26
No,
and
no,
they were produced on 14/6/26.
Let me make it clear, Lordship. They were taken into custody on 13/6/2:20 AM. When this train reached, that is. why
No,
I've
we
given
don't
the
know that. That is what we are
That
trying
is
to
why
find
I'm
out.
in the schedule, Lordship. Schedule is there. Page number 20.
Schedule of the
Lordship.
train is there,
Yes,
but we don't know if they were arrested at that time. For that we need the CD.
Lordship, on 4th, Lordship, may kindly.
All right. CD has not been received. The petitioner has spent 47 days behind bars. Learned counsel for the petitioner has sought bail on ground of delayed production of the petitioner before the magistrate. Full stop. However, on the basis of the available material, it is not discernible as to the time when the petitioner was taken into custody. Two petitioners.
Two petitioners.
Petitioners were taken into custody, which can only be revealed by the CD. It is stated by learned additional PP that the CD is presently lying in the court of the learned additional session judge. Wrong. Hence call for the CD from the said court.
Let it be on 4th, Lordship.
Is the matter on 4th?
I'm diplomat.
From the court, registry has to call. If it is in the court, who will bring it? Court will send or you will get it through?
They will send to the. Will send to the IO, I suppose. Police will collect. The PP.
Can be at 2 o'clock, my lord. I'm sorry, my lord. At 2, my lord.
May I plead, your Lordship?
FIR is page number 16. The 11th part is in page number 16. May I read?
Yes.
With due respect, I, the undersigned, owner of business premises, namely Eddy Tower, situated in this road, opposite Saraswati Vidya Mandir, so and so, beg to lay down the following. That, sir, on 16/5/2026.
My lord, may I interview? Sorry, my lord. Only to say one thing, my lord. Yes, CD is available, but 1 on 8 is there, my lord. Injury report is very much necessary. The injury report is not before us, my lord.
But injury report is also already produced by the informant lawyer in their written objection. They have annexed also. And I am behind the bar for 55 feet.
That is not injury report, my lord. That is the injury, my lord, on the day sustained. Thereafter, my lord, he was under treatment. I have given certain documents that was under treatment to substantiate that he sustained injury. Now, injury report is, my lord, with the investigating officer. my lord, medical report is to collect, is to submit before this honorable
May I plead, your lordship?
investigating officer. Who am I to submit, my lord, the injury? I have submitted certain medical,
And whatever they have submitted, it is clear. Not a single cut is there.
Regarding, injury sustained by the.
Not a single cut is there. Nothing is there. Not a single drop of bloodshed is there.
But this is during the course of treatment. Bloodshed will be, my lord, they are at the time of incident. What my learned friend is saying, my lord,
What is there otherwise in the CD?
Matlab statements are there, CCTV footage are there, matlab there are scuffles between the matlab that is there. Statement of the victims are also there. But 118 when added matlab, so 118, so injury report is very vital.
Your lordship, may I plead?
That is why I should have sent the injury report.
Matlab,
Does he think that the court will indulge him every time? He'll send the CD without the injury report. That is his conduct. Will pass strictures upon the IO.
May I plead, your lordship? Your lordship, actually, three non-bailable offense has been, section has been raised against me. One is attempt to murder. One is grievous assault with a sharp weapon. I am sure CD is very clear that no weapon was there. Nothing is there. We have the.
Is there any
video
reference to
footages.
any weapon in the CD?
matlab weapon as per the statements.
No weapon is there. Nothing, even not even a cut is there. According to the FIR,
No, 55 days is enough, I think.
my lord, your lord, may I submit?
Yes, yes, please submit.
My lord, in the bail application, my lord, they have prayed for the parity. Parity on the ground, my lord, the earlier accused, my lord, the accused Raj Rai, he has been released on bail, my lord. Considering the role or his involvement in the case. Now, this parity, my lord, the ground of parity is not applicable in this case, in my respectful. Because, my lord, these two accused persons, my lord, they have, my lord, brutally assaulted, my lord, CCTV footage goes to show, my lord, they are the, my lord, main prime suspect, prime accused, my lord. They have assaulted the accused person. As a result, my lord, the accused person sustained, my lord, head injury, eye injury, chest injury, my lord. His right has, vision of his right eye has been, my lord, lost. Now he is under treatment in Calcutta. Submitted certain documents. Now parity is my lord, not applicable in this case. Considering their involvement, my lord, they have, because they have started, my lord, assaulting. Thereafter, my lord, a group of my lord, 10 to 15 my lord, persons hounded the accused person, my lord, the informant as well as my lord, as well as the my lord, his associates, my lord, his associates also sustained. He has been immediately rushed to the hospital. He was also, my lord, rushed to the hospital. Thereafter, he has been shifted to the Calcutta for treatment, my lord. Now under his treatment, he is now under treatment, my lord. I don't know whether, my lord, his eyesight will recover or not. Now, under such circumstances, my lord, since they have prayed for parity, my lord, parity in my respect.
Yes, yes, parity, don't keep
Yes.
repeating the same argument. We have heard it. We don't have all day for you.
My lord.
Yes.
Therefore, my respectful submission, my lord, at this stage, now, my lord, another aspect is that, my lord, the whole chain has not been recovered. My lord.
your lordship, I have given the picture also.
My lord, my lord.
He has himself removed the gold chain.
My lord.
I have given it.
Gold chain has been snatched away. Rupees 2 lakhs has my lord, looted by this accused, my lord. Now these are yet to be recovered, my lord. If they are released, my lord, my lord, investigation will be hampered, my lord. And in the interest of investigation, my lord, at this.
In
stage,
fact, it
there-
is very interesting that in many cases of assault and this, we find that a gold chain has been snatched.
And he himself actually removed it. We have just given the picture of that particular thing. In page number 4.
Whatever that be,
But the FIR says, my lord, that it has been snatched away, 2 lakhs has been.
FIR
that is the
FIR
specific-
also.
if it has not been
That-
recovered in 55 days, it will never be recovered.
No, that is by reputable submission, my lord,
Yes,
because, my lord,
statements of page 24, order dated 23. There are 1, 2, 3. Into regular bill. Okay. Is submitted on behalf of the petitioner that the petitioner has already spent 55 days behind bars, and having regard to the nature of the allegations, the prayer for bail may be allowed. Additional public prosecutor submits that although the case diary has been received, the injury report not available. Is there any reason cited why injury report is not there?
My lord. My lord, not specific.
In a case of the nature involving physical assault, it is expected that the IO would be conscious of the fact that the injury report is one of the important documents while considering a bail application, but for reasons best known to the IO, he has chosen to withhold the injury report from the court, and therefore adverse inference is drawn against the IO.
In the Caesar list also no weapon, nothing, that is Caesar is not there, pen drive and all this.
What is the name of the IO?
Dhiraj Das, not sure.
Viras Das, Deputy SP Sribhumi.
He is the arresting officer.
I have the case, my lord, case that has been sent by him, my lord.
Huh?
Case that has been sent by him, my lord.
Dhiraj Das.
Dhiraj Das APS, Deputy SP Sribhumi.
Don't say IO against the officer. IO is somebody else. Jishnu Borua. And how Dhiraj Das is sent? IO is responsible for sending.
My lord, here mentioned as IO of the case, my lord.
Huh?
The document which was sent with
It mentions IO of the case. But see the FIR is handed over to, we'll investigate the case.
He has been handed over, most probably also.
Page 18.
Yes, it's.
Now he is.
Say against the IO.
My lord.
Further, upon perusal of the CD, learned additional PP submits that there is incriminating material against the petitioner. But from a pointed query from the court, learned additional PP has submitted that no mention of any weapon has been made by the witnesses. Having Mr. So-and-so learned counsel appearing for the informant has strongly objected to the prayer for bail. The ground that the petitioner hearing along with the other co-accused had brutally assaulted the victims, as a result of which they sustained injuries resulting in loss of eyesight as well. Para, having regard to the material available in the CD, the length of detention of 55 days and the submissions of learned counsel, I am of the view that further detention of the petitioner is not necessary. Accordingly, the prayer for bail is allowed 50,000 to sureties. It is further provided that the petitioner, upon release on bail, shall not try to influence or intimidate the witnesses and shall cooperate with the remaining investigation. And beg the CD.
Obliged, Your Lordship.
Not available.
CD not available, list again of interim to continue.
20 August. CD not available. Kalma.
Next time, my lord.
Here several dates, signals sent from our office 6 times, my lord. Thereafter also I have not given any reason why CD is not given.
Third learned counsel for the petitioner, learned additional PP,
Kalma.
submits that CD has not been received.
Malat, I am sorry, Malat. Here now we have received a signal, Malat. Charge sheet submitted, Malat. PS case? No. Kalma PS case number? I was seeking time, Malat.
Huh?
For a time, Malat. 1 week time, Malat.
This is the ordership reveals that today is the 6th occasion when the IO has failed to produce the CD. Full stop. Learned additional PP submits that today a request has been received for further time to submit the CD. Para. This
Result, Malat, given, Malat, just Malat. The same petitioner was arrested in the case of Howley PS, Malat, shown arrest. For that reason, Malat, that CD was recovered in that case, Malat, sent, Malat, because of that, Malat, CD is not.
He is arrested, then what is the big question?
No, he is arrested in connection with, Malat, other case, Malat, Howley PS.
So he is behind bars now.
I have no instruction, my lordship. Why
Huh?
you arrest?
I have received signal today, Malat, that I'm not.
I have no instruction, my lordship, regarding his arrest, my lordship. I don't.
In case of
Why
Howley,
he was arrested?
different case, Howley case. Howley PS case number 124 of 26. This is Mukalma. Same petition. Obidul Islam, son of Abdul Rashid of Hajipara. No?
There is something regarding identity of the petitioner.
In this case, my lordship, yes.
Another accused of the same name was granted bail.
Yes, earlier I have mentioned. Let the CD come. Let the CD come.
Learned additional PV submits being is further submitted that the petitioner is already under arrest in connection with
Only PS case number 124/20.
So what is the CD of this case doing there? What kind of a excuse is this? But it is not understood what relevance the said fact has the CD of the present case. Full stop.
Is required for issue production and shown arrest, my lord. This CD is required for production and shown arrest, my lord. To shown arrest in this case, my lord, this CD is required because of that, my lord. Already arrested in only PS case number. To issue production and shown arrest order, my lord, this CD is required. So I took the CD to that case, my lord.
Not sufficient explanation. From 29/4. It is submitted that the CD is necessary for showing the petitioner as arrested in connection the aforesaid case pertaining to Howley PS. But the same is not considered to be sufficient explanation for the failure of the IO to produce the CD since the same was called for
6 occasion, my lord.
on 11/5/2026. Having regard to the above, the interim order dated 20/07/2026 is hereby made absolute. Petition stands disposed of accordingly.
Replacement.
So in this case, it's a revision, it's a conviction under 138. Now the respondent has appeared, the court records are here. So Lordship will admit fix it for hearing, at any rate.
The short date maybe, sir, as it is a.
It is submitted on behalf of the parties that the matter is ready for hearing, as PCR has also been received. Hence, list the matter for hearing on it.
Item 38.
Please, Your Lordship. PRS bail application, Lordship. PCR was earlier called for, Lordship. Lordship will find the FIR on page 16, Lordship.
PCR not received, my lord.
Notice.
My lord, I have received, my lord. I am for the respondent number 3.
He is the victim, Lordship.
Who is 3?
I am the victim, my lord. Alleged victim.
And who is 2?
Informant, Lordship. Informant is one Gau Pradhan and victim has.
It is not necessary since victim is here. But learned counsel for the petitioner. Learned additional PP. Mr. So-and-so enters appearance for the victim, respondent number 3. Hence, notice on respondent number 2 need not be awaited. Respondent number 2, informant, who is the Gau Pradhan, need not be awaited. CD, TCR as called for has not been received. Issue reminder list again on.
Next week, Lordship. Any day.
Oh.
10 August meeting room 9.
7. Deeply obliged.
Deeply obliged.
Seven was বহুত early হব আহিব জানো TC ৰিমাইণ্ডাৰ ইছ্যু কৰি
Here your his statement has been recorded, your lordship, on 21. Initially, when we filed the petition, your lordship, due to that strike, we could not annex the certified copy. Subsequently, we have
received
She did receive, lordship. The statements are there. And whatever stated in the FIR, it is there, lordship.
otherwise, your lordship, only sections are, your lordship, below 7 years, your lordship. Custodial interrogation probably is not required, your lordship. He's cooperating, your lordship, will go on cooperating. His mobile has also been seized, your lordship. He was a class 1 contractor, your lordship, under PWD and GMC, your lordship. He went beyond his brief, your lordship. Wanted to cut from the drug peddler, your lordship, on his own, your lordship, along with 2 others, your lordship. Ultimately, landed him in this, your lordship. He got his lesion, your lordship.
the statements are there.
Statements are there. Otherwise, one witness is also there. Otherwise, one witness is also there. See, the witness has also stated the same thing, what has happened in the FIR. And he has himself stated the same thing, Lord. These things has been happened.
Mobile phone has been seized.
Yes, your lordship, mobile seized, your lordship.
It 17/7/26. TDS call for has been received. Submitted by learn. The witnesses support the allegations made in the FIR. The other hand, learned counsel for the petitioner submits that pursuant to interim protection granted by the court, the petitioner has appeared before the IO and his statement has been recorded. Furthermore, his mobile phone has also been seized. Therefore, his custodial interrogation is no longer necessary. Having regard to the above and the nature of the allegation, therefore, pre-arrest bail is allowed. The order of pre-arrest bail dated 17/7/2026 is hereby made absolute. It is further provided that the petitioner shall not attempt to intimidate or influence the victim or the witnesses in any manner.
Deeply obliged.
Back the city.
That may be possible for the timing note.
My pleasure, your lordship. This is pre-arrest bail application, lordship. FIR will file lordship page number, lordship 10, lordship. And kindly particular is page number 14, lordship, very well typed copy, lordship, in Assam. Page number 14. In this case, lordship, for the FIR, lordship, the victim was confined by the petitioner, lordship, and on 12 April at 2 p.m. lordship, and next day on 13 lordship, it was reported by the victim to her grandmother, and she was confined and committed bad act upon the victim, lordship. On next day, lordship. If I find page number 14, lordship, is the original vernacular, lordship.
Yes, PP.
Lordship, as per the CD manner and also 183 statement manner, very clearly implicated, she is a student of class 2 minor, and person not only once minor, the accused person for several times minor, he used to call the victim, and that act was done on her minor. So that all, it is also supportive of the date of birth certificate is also there, medical is also there, he is also supportive minor. This may not be minor.
But the fact of the lordship, the contents of the FIR
He
itself
has
is
made reference of some witnesses, my lord, whom she told the fact, my lord, and that witness also corroborated the fact, my lord. That's it. SCG, my lord.
not one thing is lordship, and if the victim is confined in the house of the petitioner for a one night, lordship, since 2 p.m. 12 April 2 p.m. lordship, and next day lordship on 13 April lordship, that is reported to her grandmother, and she was confined. So in between lordship, about 24 hours lordship, the father, mother, and other relatives, and there was no any charge was made out, and where she was lordship. So lordship, and the otherwise lordship, I am very specifically mentioned in my petition lordship, para number 3, and there is the dispute lordship, they are adjacent house lordship, they are residing both the informant and the petitioner lordship. And one common road lordship and village road lordship, there both the parties are used for since long back lordship. But suddenly lordship, this land is belonging from the petitioner, and subsequently lordship, the informant party trying to grab some portion of the road lordship. In this regard lordship, long dispute is going on, and even then sometimes lordship, village mail was conducted, but sometimes settled, and subsequently lordship, this FIR is most actually lost against the petitioner lordship. Otherwise, lordship, 2 years girl, lordship, and where she was for last 24 hours, and the mother, father, and other relative did not take any information. And subsequently, on next day, lordship, on 13 April, and she reported to her grandmother. And up to honorable court, lordship, how far it is, the allegation is justifiable, lordship. And if the medical lordship, and if she was committed bad act by the petitioner, so it automatically reveals lordship. But otherwise, the case is totally false, lordship. And FIR is lost on incident took place on 12th, and FIR lost on 16/4. Yes.
As per allegation, then also you had prevented her from.
And there is no fact that the 24 hours, that is what my lord friend is saying, that she was confined for 24 hours. Nothing like that, my lord. FIR, my lord.
FIR, same is on next day 13. And may I read lordship and for
She said that, my lord, on that day she escaped, and next day she
may I read
told.
the FIR lordship.
That doesn't mean that she was confined for the 24 hours.
And মোৰ আসামীজনৰ ঘৰত আবদ্ধ কৰি অশ্লীল কাম কৰে লৰ্ডশ্বিপ very clear লৰ্ডশ্বিপ petitioner is a married person, and he is one boy is a TDC first year degree student lordship. And second son is a class.
Okay, we'll see.
Lordship. Deeply obliged. Obliged.
Published, Lordship.
Delivery of judgment from Aizawl bench.
Went to court. Aizawl is there?
Yes, my lord.
Appeal is allowed.
Much obliged.
Yeah, my lord, with all respect, my lord. FIR is at page 17, my lord. Here, my lord, a man, my lord, having two wives, my lord. And my lord, 36 years of marriage, my lord. And the accused before lordship is 66 years of age, and today is around 47 days in custody. 49 days in custody, my lord. And my lord, of course, the case has been registered a little bit at a later stage, my lord, with all respect, my lord, 103. My lord, possibly it would be a case of 105, my lord. Lordship would kindly have a look at the FIR that is at page 17, my lord. May, my lord. To the council, forward. Yes. My lord, here the FIR, my lord. The date is 12 June 2026. And the occurrence is, my lord, 30th May 2026, my lord. 30th May 2026, my lord.
Yes.
And thereafter, my lord, with all respect, my lord, the forwarding report is at page 19, my lord. It begins at page 18, my lord.
Yes.
Begins at page 18. Date is 13th of June, my lord.
Very.
12, the case was registered, and 13, he was called, and he appeared, and thereafter arrested, my lord. And therein, my lord, with all respect, my lord, 19 would be, my lord, para 5, I'm reading out, my lord. The within parentheses, those lines, my lord. Death was due to coma as a result of head injuries described. All the injuries described were antemortem and caused by blunt force impact. And thereafter, 6, my lord. She was subjected to physical violence shortly before her death, my lord. This is the forwarding report, my lord. And thereafter, my lord, he was called many number of times to the police station. And prior to that, my lord, Lordship, may kindly have a look at page 20, where the age is apparent of the accused, 66 years of age, my lord. Lordship may have seen, my lord. Page 20, the forwarding report, the age has been given against his name, corresponding to his name, my lord. Sahidur Rahman, this is it, my lord. And thereafter, my lord, he was, prior to his arrest, my lord, he was called several number of times, my lord. It begins at page 25, my lord. No flight risk. Page 25, my lord. He was called. He appeared, my lord. And 25, my lord, there is a PR bond executed upon being allowed to go home. 26, another PR bond, my lord. Oh, same, my lord. I'm sorry, my lord.
27.
27 is another PR bond, my lord. 27 years. Thereafter, on the prior to his arrest, he was called and he appeared, my lord. He's 66 years of age, my lord.
Voluntarily.
He voluntarily appeared, my lord. And my lord, three things are very important, my lord. That definitely, my lord, that one incident, my lord, in the trial he will have to face, my lord, and the consequences also, my lord, if any, my lord. But only thing, my lord, here age is 66 years. Today, for around 48 days in custody, and therefore it would not be or may not be a case of 103, my lord, because it is apparent, my lord. Age, my lord, with all respect, my lord. Injury PR has to postmortem report. In the affidavit, they have given in the objection, my lord, the page 72, the postmortem report is available, my lord. In the objection application filed by the first informant, my lord.
Available in the CD also.
Yes, my lord. Why I'm saying, my lord? 74, my lord, with all respect, my lord, no weapon or anything, not premeditated. 74, my lord. Opinion, I am just reading out, my lord. Death was due to coma as a result of the head injuries described. All the injuries described were antemortem and caused by blunt force impact, my lord. Now, my lord, with all respect, my lord, the two wives, some problem somewhere, my lord, 36 years of marriage. And this is the incident, my lord, with all respect, my lord. Unfortunately, it happened. And now, my lord, section of law attributed, with all respect, my lord. The trial is a different thing, my lord. Whether he has committed or not, that's a different matter altogether, my lord. Whether his custodial in detention is necessary at this stage, my lord. Now, my lord, 103. 103, my lord, with all respect, my lord.
105.
105, my lord. Murder, my lord. 101, my lord. Murder, my lord. They are the exception I am reading out, my lord. 4, my lord. I'm just reading out, my lord. Lordship knows, my lord. I'm just reading out, my lord. Not necessary, my lord. Lordship knows, my lord. And my lord, it would possibly, ultimately, my lord, when charge seated, my lord, it would possibly a case of 105, my lord. 105 part 2, my lord. Because it was not premeditated, neither intention nor no premeditation, my lord. It would be, my lord, with all respect, my lord. Lordship knows, my lord. Again, for the sake of repetition, I'm repeating, my lord. Punishment for culpable homicide not amounting to murder. The second part, my lord, with all respect, my lord. Shall also, my lord, with all respect, my lord. I begin. If the act by which the death is caused is done with the intention of causing death or causing such bodily injury as is likely to cause death, or with imprisonment of either description for a term which may extend to 10 years, with fine, etc., my lord. Possibly it would ultimately be, my lord, with all respect, my lord, would be a case of 105. And the last parting line of this section is very important, my lord. If the act is done with the knowledge that it is likely to cause death, but without any intention to cause death, my lord. Possibly it will fall in that category, my lord. Both went to their separate, my lord, hearts, my lord, with all respect, my lord. Same house they reside, my lord. And this is the situation, my lord, with all respect, my lord.
Is the first wife or second wife?
This is the first wife, my lord. Second wife and first wife, they've been staying together since long, my lord. And my lord, there may be allegations, counter allegations, my lord. But whether, my lord, he has committed it or not, my lord, that's a different matter altogether, my lord. And for 20 years of marriage, my lord, they have been staying together, my lord. Second wife married 20 years back, my lord, because no issues, possibly because of that, my lord. And my lord, of course, my lord, judgment I should not rely upon, my lord. Even Apex Lordship knows, my lord. Of course, that is at the stage of judgment, my lord. Apex Court, my lord, when the lady was burnt alive, even that was, my lord, earlier 302, it was made, my lord. One line I'll just read, my lord. This is Dattatreya, my lord, with all respect, my lord. Lordship has referred it many number of times, my lord. Ultimately, it would be possibly a case of 105, my lord. Yeah, my lord. I'm reading para 20, my lord. Lordship.
Yes.
May I just read it, my lord, with all respect, my lord.
from every available evidence which was placed by the prosecution, it is a case where a sudden fight took place between the husband and wife. Here also no premeditation, my lord. The deceased at the time of carrying a pregnancy of 9 months, and it was the act of pouring kerosene. There, my lord, furthermore heinous, my lord, pouring kerosene on the deceased that resulted in the fire and the subsequent burn injuries and the ultimate death of the deceased. In our considered opinion, this act at the hands of the appellant will be covered under the fourth exception, as I read out, my lord. I did not read out, my lord. Lordship knows, my lord. Fourth exception, now, my lord, also. The fourth exception, my lord, 103, my lord. 101, my lord. Sorry, my lord, 101. Exception given under section 300 of the IP, then 300, now 101, my lord. Culpable homicide is not murder if it is committed without premeditation in a sudden fight. Exactly the same, my lord, with all respect, my lord. Same spectrum, my lord. In the heat of passion, upon a sudden quarrel, without the offenders having taken undue advantage or acted in a cruel and unusual manner. If pouring kerosene and burning doesn't fall in the category of unusual manner, my lord, without weapons, a very unfortunate happening that should not have happened, my lord. This is it, my lord, with all respect, my lord. And my lord, this authority quotes everything, my lord.
Sudden fight, heat of passion, that is when both sides come with danda and not husband and wife. This is not applicable.
That is also
Husband
well,
killing his wife.
There are here also wife, my lord. That's why I read that. I thought it would be appropriate, my lord. Just placing things, my lord, may not be necessary, my lord. Why I'm saying, my lord, definitely, my lord, at the time of trial, my lord, whatever needs to be done, that has to be, my lord, the consequences he will face, my lord. But only thing, my lord.
There the court had all the evidence before it, which it analyzed and then came to a
Yes.
finding. We are at this stage, what do we have?
Only thing, my lord, whether at his age, my lord, and after even around for 50 days, my lord. 90-day period offense, definitely, my lord. 50 days there, 66 years of age. And my lord, he never paid for PRS bail. Lordship would kindly peruse the diary. And if there are lordship finds, my lord, that there are something furthermore, my lord, adverse against me, my lord, that whatever I have stated, beyond it, something is there, my lord. Definitely, it would not be a case. Otherwise, my lord, if possible, my lord. My lord, I never came for PRS bail. Police, no flight risk, my lord. I was asked to appear. Dutifully, I appeared, my lord. All these things are there, my lord.
Why do you come for pre-arrest bail when police are so nice to you? They release you on PR bond.
Oh no, but that time post-mortem report did not come, my lord. That is why it was not raised. Before the post-mortem report, my lord, honestly, my lord, police is good, bad, ugly, I'll not go into it, my lord. Police did not arrest me because of the reason possibly, my lord. Post-mortem report was available on 12th possibly or 11th, my lord. So FIR was also, the FIR was lodged on 12th, my lord. So he was called and I appeared, and on 13th he was arrested, my lord. Whether, my lord, the lordship could kindly see after perusal of the diary, my lord, whether my further custodial detention is necessary or not, my lord.
Let us now see how nice police is to you. Yes, prosecution.
Malat is 61 years old already, Malat, and informant is the brother of that disease, Malat. Now, his statement is there, Malat. I am coming to the statement of one witness, Malat. Prior to the incident earlier, Malat, as per the statement of the informant also, Malat, he was, Malat, physically assaulted earlier also several times, Malat.
No complaint.
Well, no complaint, that is there, Malat, yes. But as per the statement of the witness, on the date of Shivaratri, Malat, at about 8:30 p.m. Malat, night, Malat, she came in an auto and she unable to walk properly, Malat. What yesterday, what happened to you, Malat? Then it is tortured by husband. So tortured by husband, not
on that day, no?
not
Earlier.
prior to that, Malat. So tortured by husband, it is said by the informant being a brother. It is also said by the other person who is the neighbor, Malak. Neighbor is seen, Malak. That is now, prior to that incident, earlier night, when the husband is torturing Malak, at that point of time, is the disease, it's phone call with the brother, informant, Malak. And the brother, what happened, he recorded everything in his mobile. He himself stated that at that point of time, he was tortured. And subsequently, Malat, Malat, in the morning, by the informant, accused, that she was found dead in the bed. And after the postmortem report, it is my lord already shown by Learned Senior that it's a due to my lord head injury. Now injuries are my lord there, and after that phone call that given in a pen drive seized by the IO, and voice samples and all these were sent to my lord FSL, that is there my lord. So continuous torture, that is he has elaborated, and that is also reflected in the statement of the witness, my lord, neighbor. And second, he's the first wife. After the second wife marriage, my lord, there are torture as per the statement of the witness, my lord. And my lord, incident occurred on the 31st of May, my lord. In December, the informant, that lady, and informant son, they went to Makkah. At that point of time, she was my lord, fit, and doctor's fitness certificate was there. Everything is fine. Subsequent to that, also in February, February or April, well, the accused and the whole family went to somewhere for she was fine. So immediately
Relation was good, my lord. They went together, my lord, outside Assam, my lord.
But she was quite fine few months back, few months earlier. Now, obviously, my lord. And postmortem report, what status is corroborated? Postmortem report is that there are injury, and head injury is there. And as per the statement of the accused, my lord, সেইদিনা ৰাতি অকণমান কাজিয়া লাগে, মই দুচৰমান মাৰিছিলো, তাৰপিছত তেওঁ বেলেগ এটা ৰুমত শুই যায়, মই নিজৰ ৰুমত শুই যাওঁ ৰাতিপুৱা 5টা বজাত. So he is not telling the truth, my lord. Head injury is there.
Why will he implicate himself?
That is there. By slapping, my lord, head injury will not come. I have tried my custody, my lord, my lord.
Well, only one line, my lord. But honestly, my lord, whether bail is granted, besides the point, my lord, that because of the marriage with the second wife, that took place 20 years back, and 2 daughters, my lord, and one daughter was shouting in that audio clip that he has not said, my lord, that take her to hospital. Father, my lord, 66, at night he went to his own room to sleep, and the lady went to her own room to sleep. I'm not saying that she was not tortured, but habitual torturing, it is contradicted by himself, my lord, that the family went together, both the wives, outside Assam, and she was Helen Harty, my lord. And all of her treatment papers, my lord, it was not that habitually, my lord, having fracas, my lord. That would not be possibly in the spectrum, my lord. Of course, my lord, I'm not saying that he did not hit her there. No instrument, nothing, and no premeditation apparent, my lord. But I never say that, my lord, hitting was good. I'm not saying that. But Lordship would kindly peruse the diary, my lord, days and age and everything. And no police custody was sought for, my lord. Because the reason, my lord, Lordship said that I had, Lordship is correct, my lord, because I was allowed to go on PR bond. Because when I was allowed to go on PR bond, my lord, police was possibly waiting, my lord, so that medical, postmortem report could come, my lord. When it came, my lord, and that it was divulged from there, that, my lord, head injury or something, my lord, he was called and picked, my lord. Staying in jail and staying outside, my lord. Of course, my lord, that report.
The daughter is there.
Yes, daughter is there.
Daughter's statement is there.
Daughter's statement
has to be there, my lord.
Who
I
has
have not
heard
checked,
that?
my lord. I have not checked, my lord. I'll check, my lord. I'll check, my lord.
Yes, my lord. Doctor Lora ase niki? Lora ase.
I'll check, my lord.
So, my lord, daughter and son, my lord, they were present. Their statements are to be there, my lord.
Yes, in the meantime.
Also, the incident took place on 30/5/2026 at around 10 to 10:30, Your Honor, at night. At that time, my elder sister called me up and said, like, my husband is assaulting me. And at that time, as my senior counsel has already said, like, the informant heard that the stepmother if she shall not be provided with medical treatment. Same thing, Your Honor. If she would have provided with medical treatment, she wouldn't have died. That also, the accused has let her die. Even as per the officer has already said, like, it's in the CD that he already admitted that he assaulted her. No matter what, 2 slaps at all, it's already been there, Lordship. And moreover, Lordship, maybe I'm the first wife, my elder sister was the first wife, but due to health issue, I don't have any children. Lordship. Due to that issue, every time I used to get assaulted by my husband, the accused. And moreover, the postmortem report has already reflected the fact that she was died because of blunt force of impact, Lordship. So it's an obvious case, and moreover, Lordship, he's a wealthy man, Lordship. He's a wealthy.
All right, let's move on.
My lord, and can I just say that what the informant also didn't come, my lord. When he heard everything, when he never visited the deceased's house, my lord.
Lordship,
And there is another section of law 106, my lord. My lord, nobody knew that she would expire. Otherwise, my lord, that she was not taken to hospital, then, my lord, it would be a better case for me, my lord. 106 would be applicable, my lord. 106 of the BNS.
Lordship, in our page number 62, para 5, you have already mentioned that on her call, deponent, the present informant, has already made a call to the accused and requested him to not to do anything. And in the morning, he will come and he will take up the things in their mutually, or mutually they will go. In the morning, around 5:30, the accused gave a call to informant, Lordship. She died. On our reach with my family members, we saw my elder sister hands were twisted, a bunch of hair lying on the floor, and she was lying on the bed. Lordship. So this is a cruel murder, Lordship. My humble chamber before Your Honor. And moreover, about the detention of the length of detention, Lordship, the petition side has already taken more than 3 adjournments already, Lordship, after the CD has been received by this honorable court. That is why the length of detention has been.
Let us give them 3 more.
More than, sir.
They will have a better case then.
My lord, the son and daughter statement may kindly be looked into, my lord. Highly obliged. And this Suli part, my lord, sorry, here found there, neither in the FIR nor in the forwarding report nor in any police report.
The informant, whatever.
This is her version, my lord. The informant, my lord. My lord, these are immaterial, my lord. With all respect, my lord.
ECR has been called for murder. Yes, petitioners, my lord, they are not the named accused, my lord. Statement of the victim as well as other witnesses, my lord. The petitioner's name has not been mentioned, my lord.
Is the petitioner's name?
Lord,
Is the petitioner's name?
petitioner's name appeared in the search sheet only, my lord.
What is his name?
Mubarak Ali and Israel Khan, my lord. Mubarak Ali and Israel Khan. Their names have not been included in the FIR as well as other part of the. Now, my lord, they have received the summons from the court, my lord. Case is fixed on 5th of August for appearance, my lord. They will appear, my lord. They are ready to face the trial, my lord. My lord, the specific allegation against one Zagir Hussain, my lord, subsequently appears to be Muhammad Ali.
So who is this? The petitioner is a different person, PP?
Yes, my lord.
Date.
You are for the informant.
Yes, Lordship, respondent number 2, but we filed the wakalat number file today, but we have not received a copy. Yes.
Mubarak Ali.
Your name is shown.
Jayana Kandokar.
Your name is there, no? Furnish copy then.
My lord,
She is appearing for respondent number 2.
yes.
Furnish copy. She has not got the copy.
Notice has been issued to me. After receiving the notice, she has been engaged, my lord. And she is not the legal aid counsel, my lord. She appears for respondent number 2, my lord. The notice has already been issued to him.
Yes, how did you?
In
How-
fact, my
you
lord,
got
the
notice?
informant, being the informant, my lord, he never alleged any allegation my lord, against the present petitioners, my lord.
She is not legal aid. She has filed a wakalatnama.
Yes, my
That
lord.
is why she must have received notice with copy.
Yes, my lord.
Then go through. If any involvement of him is there, you have not gone through, I think.
I have not gone through. Malad,
Go through. Why his name is there? That is what we want to know.
Rest, my lord, they are ready to appear in the
Try to
basic
see
trial, my lord.
just after some time.
That's- Lordship, kindly pass out the matter for the day, Lordship. Senior Counsel H.R. Chaudhary will argue in this case.
Prayer of learned counsel passed over for the date list again on
4th of 8th, Lordship. 4th August. 4th of 8th. 4/8.
Yeah, please, Lordship. FIR at page number 10, Lordship. It translated copy, Lordship, vernacular copy, page 14, Lordship.
Did you receive?
Did you receive, Lord?
Jury report is there.
Lordship, the injury report is there.
My condition is that, Lordship,
According to injury report, Lordship, of Mukhtar Hussain is simple.
as per the FIR, Lordship, they have stated that 4/6/2016, there is an incident. There is no incident as such, Lordship. On 3/6/2026 evening, regarding uploading some bamboo in a tom-tom, Lordship, they have some dispute. There is no injury, there is no physical alteration between the
But in
parties,
page
nothing.
17, Lordship, it is stated that I have carefully gone through the case study from the materials so far. It transpires the allegation made in the case are voluntarily causing grievous hurt by dangerous weapon.
Who says?
In this order, Lordship.
This is the rejection order of
Reject the
the.
order of the additional session judge.
Of?
Additional session judge, Lordship. Learned additional session, page 17.
So, but injury report does not say.
It is there,
It is
but it is
simple.
stated only simple. I don't know, Lordship, why it.
There is nothing, any incident as such in this.
As in, Lordship, I look into that. In page 17. It is clearly stated that I have carefully gone through the case diary.
In paragraph 5, Lordship, actual fact we have stated in paragraph 5, Lordship.
No, whatever, he may state anything, but the case diary is before us.
Okay, it is fracture, abrasion in wrist, knee, swelling, superficial related injury. Injury is there.
Eh?
Injury is there.
one informant that is Nawaz has shown me one report that there is fracture is there. He has shown to me. His fracture is there.
4/6/2026, Lordship, there is no any incident. They have lost the FIR on 6/6 after 2 days, Lordship. There is a small incident on 3/6/2026. Whatever they have information stated in the FIR, this is totally a story, Lordship. Paragraph 5, we have stated the original incident, what happened, Lordship. They have lost the FIR on 6/6 after 3 days. If there is any serious grievous heart, Lordship, after 2-3 days, there is no delay also explanation in the FIR, Lordship, nothing.
So injury is what?
Yes, it is simple.
Simple,
Simple.
no fracture.
There is, but there is only abrasion in wrist, knee, swelling in temporal region, Lordship. And in the witness.
Learned counsel for the petitioner and learned additional PP. This is an application under so and so as per. Go to page 16. Okay.
17.
2 marked. The CDS called for has been received along with injury report, which indicates only simple injuries. And the investigation of the case has also progressed further. Having regard to the above.
147.
The court is of the view that don't say court. Having regard to the above, the custodial interrogation of the petitioner may not be necessary. Accordingly, prayer for pre-arrest bail is allowed. 50,000 plus securities. Shall not try to contact the. Shall not try to intimidate the victims or witnesses in any manner to cooperate with the investigation. It is further provided that the petitioner shall appear before the IO within a period of 10 days of passing of this order.
Oblige, Your Lordship.
Item 54, that murder case, I have checked the and hand over the CD statement of the son and daughter, because diseases have no son and daughter. It was from the second wife. Their statements are not there.
Not there.
Not there. Other witnesses are there, some nephew and all this. Their statements I have taken on this side.
May please your lordship. As per office noted 22/7/2026, neither registered nor unsub notice returned back in favor of respondent number 2, lordship. Kindly allow us to take first steps.
You are for?
I'm for the CBI units. Respondent number 1. Respondent number 1.
Who is to informant?
Informant, lordship. With regard to the question of law that prosecution sanction has not in respect of PCI. As your lordship well aware that the law is very clear. For the IPC, no sanction is required. So cognizance has been taken in the IPC sections. And the law is very clear to that effect, and the latest judgment is also there. And since long it is pending. Cognizance has rightly begun because PC Act sanction is denied. However, the cognizance is taken only IPC.
Yes. For that we don't have to hear informant.
Lordship, kindly fix it at admission hearing. And that date, lordship.
This petition itself is not maintainable, but some or the
But
other
my
reason.
senior is out of session. He will
It is,
come.
okay, then a date may kindly be given, that is not issue, but the.
Alright,
one of the
learned
other reason it
counsel
is
for the
getting-
petitioner and learned standing counsel for CBI. It is submitted that notice on respondent number 2 is not complete. However, learned standing counsel for CBI has submitted that the matter hinges on a law point, that is as to whether sanction is necessary when cognizance has been taken only under offenses under the IPC. Full stop.
It is mentioned in their petition, your lordship. Accordingly, their prayer is that.
Since the question revolves around a limited point of law, the matter can be taken up for disposal at the admission stage. Hence, list the matter for admission on so and so.
There is an interim order, lordship.
Interim order passed earlier to continue till the next date of testing. Why have you made the informant a party? Is it a necessary party? This is not POXO or anything.
Made the party. Is their petition, your lordship. Since long it is stayed, so paying for
When?
sorted. Here on 13th or 17th of August.
Alright.
Much obliged, your lordship.
May it please your lordship, lordship, as per office note dated 22/6, 2026, service completed, lordship.
What is the delay?
Delay, lordship, 338 days.
What is this appeal? Division? What?
Division, lordship, criminal division.
What is the case? NI Act? Huh? Dimma. Where are the cattle now? Huh?
What is kettle?
Cattle is pending for so long. 23. Are they even alive?
Report has to be called for.
And then let us condone the delay. Learned Council IA. Petitioner and learned edition. It's on respondent number 2 is complete, but none appears. The IA has been preferred seeking condonation of delay of preferring delay of 338 days in preferring the connected criminal revision petition. The reason for the delay is stated to be the medical condition of the petitioner, medical as well as financial condition of the petitioner. It is stated that he was suffering from cardiac, diabetic, and diabetic and hypertension, and is under constant medical treatment and medication. For his treatment, he had to incur huge financial liability and had to borrow money to prefer the present revision. Having regard to the cause shown, and since no objection has been filed, the court deems it fit to condone the delay in preferring the connected criminal revision. The I stands allowed accordingly. Has to be registered.
Obliged lordship.
May I appeal, Lordship, as per the last office note, Lordship, the service report upon the respondent number 2 is complete, Lordship. Then the matter may be come up for admission, Lord.
Third learned counsel for the petitioner and learned additional PP as per office note, service on respondent number 2 is complete. However, none appears for the respondent number 2. And so list the matter for admission.
Lordship, there is an interim order, Lord.
Interim order passed earlier to continue till the next date of listing.
May it please your Lordship. Lordship, here as per the records, no office note has been given for the second steps which we have taken with corrected address of the respondent number 2, your Lordship.
It is submitted by learned counsel for the petitioner that fresh steps has been taken on the respondent number 2 at the proper and correct address, but the same is not reflected in any office note. Full stop. Hence, registry to prepare office note in this regard and list the matter again on so and so.
Lordship, interim, there is an interim order, it may be extended, your Lordship.
Interim order passed earlier to continue till the next date of listing.
May I brief? How much? Can it be little early?
নালাগে একটু আগতে দিয়ক এটো এনে
So order
সার্ভিসৰ কাৰণে আছে বস্তুটো
highly obliged, your Lord.
Please, your Lordship. Lordship, on the last occasion, the death certificate of the appellant was called for. Is tagged along with the record.
So he is the appellant, Sirajul.
Lordship. Committed suicide inside the jail premises.
Who is dead? IA criminal 330 2026. Received the third learned counsel for the petitioner and learned additional PP. Here is the report of the superintendent, district jail, Nolbari, dated 24th of July 2026. Forwarding a certified copy of the cause of death of the convict stroke appellant Sirazul Islam issued by the Department of Forensic Medicine and Toxicology, Nalbari Medical College. Wherefrom is reflected that the appellant has already expired and post-mortem examination was conducted upon him on 22/06/26. In view of the above, the appeal stands abated. You are amicus for the petition. It will appeal the order to in view of order passed in so and so. I also stands disposed of. Main costed order to delay whole appeal to say 105 nahi.
Your Lordship, as per office note dated 29/7, we have taken steps, but the step returned as unserved. They allow us take these steps.
So how will you take steps? Address he has left.
Take the step in new address.
Learned counsel for the petitioner submits that he may be permitted to take fresh steps on the respondent, as office note has indicated that the notice has been returned unserved with postal remark within quotation RTS address he left. Those petitioner is accordingly directed to take steps after verifying the proper
Your Lordship,
address.
if entry order pass earlier may continue.
Let's complete the dictation at least. Address of the interim order passed earlier to continue till next date of listing.
Regular appeal, my lord, here is a IA, my lord, for bail. We have annexed the evidence as well as the FIR, my lord. My lord, 64 of the ANS, my lord. And the FIR lordship fine, my lord, I'll be 64 is the FIR, my lord. FIR just showing because we have lordship see, my lord, the FIR was lost by the victim herself, my lord. Page 64, my lord.
Page
64, my lord,
of our IA, my lord. IA is IA criminal 90. 90/26.
What is the sentence?
Sentence for 64, my lord, is 10 years, my lord, that fixed sentence of 10 years, my lord. And he is inside for around 8 months, my lord, exactly, my. And here, my lord, that she, my lord, page 64, my lord, the affair, my lord, informant herself lost this affair. She stated that she was alone in the house, my lord, her husband was not there. Thereafter, my lord, the present appellant, he entered the room, my lord. She thought that it was her son, my lord. So, my lord, he committed the offense, my lord. Page 65, Lord should see, my lord. Although the occurrence took place on, my lord, 3/3, my lord, 7:40 p.m., my lord. It was lodged on the next day, and it was that GD entry 6:20 p.m. next day, because in her evidence she stated that in the morning she had lost the affair. That's why I'm showing it, my lord, page 65. Now, my lord, coming to the, my lord, her evidence, my lord, kindly have a look at, my lord, page 70, my lord. In gist, she stated that her husband was not there. Husband went to theater. So during that period, the appellant entered her house. She thought that it was her, my lord, son, my lord. And thereafter, my lord, the offense was committed. My lord, and she stated that she called her husband and stated that you come quick as early as possible. And 15, my lord, that page 71, kindly see, my lord, the next morning, my lord. Apparently, in the next morning, she was not there because it was registered in the 6:20, my lord, PM, my lord, evening, my lord. And, my lord, the accused, my lord, was working with the, my lord, brother-in-law of the victim, my lord. The husband's brother, my lord. Page 72, Lord should find that, my lord. So he was known, my lord. And, my lord, page 72, now that one, my lord, cross, Lord should find, my lord. Who the accused stays with so-and-so, that is the brother-in-law, my lord. Now, my lord, 5, my lord, on that day, she went to the house of the accused, my lord. 5, my lord, cross, my lord, page 72, in the morning. She also met him, my lord. After 9, my lord, there is a suggestion that she called the petitioner, appellant, my lord, around 24 times, my lord. She denied that, but from the 161 also and 164, my lord, that now 180 and 183, my lord, that she had telephonic conversation with him all the time, my lord. And page 73, Lord should see, my lord, that 12, my lord, that, my lord, the next day of the incident, husband summoned the accused. But in fact, my lord, the husband stated that it was on the day of occurrence, my lord, date of occurrence, that he tried to contact the accused, not the next day, my lord. These are some material contradictions, my lord. And then from 17 onwards, my lord, these suggestions were put, and it was, my lord, proven by the IO also that she did not state those things, my lord, regarding the son being there, and also regarding that the husband came back again, my lord. He went to the theater, he came back again he went, those part not stated. And even regarding the commission of the offense also, that 20, my lord, lordship, that was never stated before the husband. And now, my lord, and she denied that she had telephonic contact, my lord, page 73, 21, my lord, she denied that suggestion, my lord. But 74, 22, Lord should find, my lord, I sometimes used to speak with him, my lord. So he's a known person, and we say it's a case of false implication, my lord, because he did not commit the offense. He was not, she proposed, my lord, he did not accede to it, my lord. 75 is that husband, my lord, husband's, my lord, evidence. Last line, my lord, that 6, my lord, I went to the house of the accused, my lord, kindly say, but he was not present. That is on the day of occurrence, my lord. And 76, next page, my lord, next day, my wife lost the case against the accused. And he also admitted that he was working with his brother, my lord. And 78, my lord, Lord should kindly see, my lord, that is the relative sister-in-law of the, my lord, husband, my lord. Page 78, Lord should find that in the morning he asked this particular witness that whether the accused comes to his house, my lord. Case 78, my lord. 4. Now, my lord, kindly have a look, my lord, at my lord 82, my lord. The IO, my lord. PW5, my lord. 3, my lord. So it was only on the next day, my lord, I received the azure from complaint so and so, white so and so, GD and dated so and so at 6:20 p.m., not in the morning, my lord. And regarding my lord,
That was lost that evening.
yes, my lord. Kindly see that my lord, time, my lord. She stated I went lost it in the morning, my lord. In the in her evidence, my lord. But here lord should see that was GD entry first in point of time, my lord. That is at 4/3/2025 at 6:20 p.m., my lord. That 3. My lord, yes, I am skipping, my lord. Page 84, my lord, of the IO, my lord. So that portion that husband came again, never stated, my lord. Then, my lord, 85, my lord, 16, the victim did not state before me that her 2-year son was at his daughter's house, which is near, and she thought that it was a son who returned and opened the door. So she stated that I thought it was my son. Then, my lord, regarding how the occurrence took place, 17 and 18 also, my lord, that husband never stated, the victim never stated to her husband how it occurred, my lord. Kindly see is that 18, my lord. And now, my lord, most importantly, kindly have a look at 87, my lord, the evidence of the, my lord, that my lord, doctor, my lord, medical officer, my lord. Kindly see the case history, my lord, page 27, 87, my lord. Was contacted the next day, my lord. The victim was in relation with a boy named so and so, since so and ate her over phone since then, and today at so and so, that is on the time on the day of, my lord, the next day of occurrence, my lord, the victim had so and so with the boy, and she also filed a complaint against the boy claiming so and so. So this is the case history, and there was no evidence of any forceful sexual relation intercourse, my lord. Now, Lordship, kindly the learned trial court, my lord, consider the 160, that 180 as well as 183, and stated that everything has been corroborated. Kindly have a look at page 36, my lord. What she stated in her first statement before the investigating officer, my lord, page 36, my lord. The judgment, my lord. Page 36, since so and so's, that 35 subpara, my lord.
Yes. Kindly see, my lord, since so and so, I've been talking with accused so and so over phone on so and so. So and so asked me whether I love him. I talk to him with so and so over phone. I make telephonic call to A1, and he also makes telephonic call to me. AI started to talk with me over phone involving illicit affairs. I informed this to my husband. The husband prohibited me from talking with so and so A1. That is the appellant, my lord. So this is, my lord, then how occurrence took place. 3 about so and so went to our house. At that time, none was present in the house. Taking the advantage of absence in the house, so and so entered and closed the door, hugged me and kissed me, and established physical relationship with me. When my husband returned home, I informed. So next, my lord, in her 183, that is 164, my lord. So and so is my husband, so and so, my lord. I know him from the day of my marriage. And, my lord, although husband, my lord, they never lost any affair, my lord, and possibly going through this evidence, and, my lord, whether it's a case of that
can it be said reliable and sterling quality, my lord? Three different versions, my lord. Fixed sentence, he is inside for around 8 months, my lord. How the the manner how the occurrence took place, as well as that regarding the time when she lost the affair, my lord, morning and not necessary, one on that affair, my lord, lost. Yes. Very fixed sentence, lordship had already, lordship is ever approved, my lord. And regarding the time of that lodging order, should I place on possibly not necessary? Should I place nothing, my lord? Time of? She stated in that morning, my lord, and in fact it was in the evening, my lord. On that point, should I show, my lord? Yes, PP.
Does hardly matter, my lord. Can we dispose of that finally? He has relied on all the evidence of all the witnesses, my lord. What is left more, man?
अरे देखाओ डेली order देखाओ ना
Conviction is based on the basis of the statement evidence of the prosecuted PW1, man. Yes, my lord, it is not necessary to, my lord, add on all the, my lord, particulars of the evidence of all the witnesses, my lord. This says, my lord, it is not necessary to, my lord. Only the prima facie, my lord, there is a case or not, my lord.
It's fixed sentence, no judge. Exception, then only.
Yes, for the. Amicus, sir. You're appearing as amicus or engaged?
Yes, yes, Your Lordship. Your Lordship, what I'll say here is since only 8 months of Your Lordship, and there are only 6 witnesses. The TCR is also there, Your Lordship. The matter may be finally heard on a day fixed, Your Lordship. It will be done in one session, Your Lordship.
Come out, my lord, because let him come out, my
Your
lord.
Lordship, does not make sense to grant him bail right now, Your Lordship. The matter can be finally heard of. Only 6 witnesses.
No, there is no bar in considering that there is no bar in considering that his bail, no. And we are on the
Only there is a chance that the matter.
knows, my lord, when hearing. So many cases are pending, my lord, long.
We have to go through the entire evidence.
Fixed sentence part, lordship is.
Same thing, like hearing the appeal.
So only that regarding that fixed sentence part and my lord.
No, you are on the fee, but there are diametrically opposite judgments.
Those are there, my lord. Yes, those are there.
Recent judgment is there.
Yes,
saying
it is
unless there is something gross and palpable, then it should not be
Yes, that is
suspended.
there.
That is also there.
Looking into the evidence also, my lord, and that, my lord, my lord, whether it can be, she can be stated to be a sterling quality and all, my lord.
Your Lordship, because the accused, he has already stated in his statement that he had gone to the house of the victim, Your Lordship. Now, whether it has happened or not, Your Lordship, only after we go through the evidence, Your Lordship.
Before the medical officer, kindly see what she stated, my lord. The case is.
That is what is,
It is apparent, my
rather,
my lord, there is two sets of witness. That is the she supports the, my lord, case of the, my lord, accused
Well,
appellant.
madam, nothing may come.
No, I am not with the case history. Oh.
Case history, madam, your case mentioned, madam.
He is the independent.
He's a boyfriend, madam.
She is an
So one
independent,
fact
my
is
lord.
true,
She is a
madam.
medical
He
officer.
can
my
take
lord.
the actions of his over husband, madam.
She is not my
Husband was not
witness.
there.
She is not my
Whether
witness.
the act was consensual or not, Your Lordship, it depends on that, Your Lordship.
Apparently, it is the
If-
witness
how
there.
do you, how do you explain the medical history?
It is their witness, my lord, not mine, my lord. It is not the defense witness, my lord. Their witness, my lord.
All right, we'll see.
My lord. Much obliged.
I will be disposed of. I
Oh, fine.
will be disposed.
Yeah.
Much obliged.
No, 58, my lord, one thing I have gone from, my lord, from the TCR, my lord.
Hmm.
The victim 183 statement is not available in the TCR, my lord, which is very much important. Because this accused person, my lord, they were shown absconder in the search sheet, my lord. Now, my lord, someone has been issued by the trial court, my lord, not the appearance court, my lord. Now, they are not appearing because with the appearance of that, they may be put behind the bar, my lord, once they appeared, my lord. Now, my lord, what are the, my lord, implication against them, my lord, only I have verified from the search sheet, my lord. If Lordship peruse the search sheet, implications are there, my lord. Against, my lord, one witness I have found, my lord. Regarding the other, my lord, it is not found directly, but they were present, my lord, at the time of incident, my lord.
Present petitioner is Mubarak Ali.
There are two petitioners, my lord.
Two
One-
petitioners.
Yes, one name is Bablu, one name is, my lord, Babla, my lord.
But 183 is not there.
It is not there, that may be called from, my lord, at this stage. Whether, my lord, he is implicated or not.
From perusal of the FIR as well as, my lord. Their names are not here, my lord. FIR has been lost, my lord, on the part of the victim, my lord. His elder brother has lost the FIR, my lord. Hearing the victim, my lord.
Who is the Muhammad Alin?
Muhammad Ali.
Alin, huh?
Muhammad Ali is the main accused, my lord, who appears to be in the FIR, my lord, as Zagir Hussain, my lord. The search sheet, my lord, Zagir Hussain's name has been name is Muhammad Ali.
So he has been implicated, that is all right. Now, how many names do you have?
Lord?
How many names do you have? Only one name. Bablu or Babla? Who is Bablu Babla?
That will be
My
clear from
name
the,
is Mubarak Ali, my lord.
that will be clear from the search sheet, my lord. One is Mubarak Ali, my lord. His name is probably Babla, my lord. And one is Israel Khan.
Israel
His
Khan.
name is Bablu, my lord. Israel Khan.
Israel Khan is Babla.
My lord, that you will find from the search sheet, my lord. Vernacular search sheet, my lord. Assamese portion.
In the statements of witnesses also it is there, Israel Khan Babla.
Yes.
In the FIR, my lord, their names have not been recorded. Yes, my lord, as search sheet has been submitted, my lord, and the trial is going on, my lord, the petitioners, my lord, they are ready to face the trial, my lord. On 5th of August, my lord, case has been fixed for appearance, my lord. They will appear on that date, my lord. In the meantime, they may be protected, my lord. They will face the trial, my lord. There is my lord no allegation against them, my lord.
Police statement is there, victim.
The index can go.
When police statement is not there. Then
183, both are not.
won't be safe to,
But that two statement may be called for, man.
because they are the only, he was the other three, all three are, I think, involved. Some way.
Yes, Ismail, my lord, there is some allegation, my lord, that has been very co-accused, my lord.
183 is here. Last, I think it is. Was it there fully or not? Only part of it is there. Only up till just this much. Continuation is not there. Call for it then. If possible.
In the meantime, my lord, they will appear on 5th of August, my lord. In the meantime, they may be protected, my lord.
Let the explain be called for in the next.
Yes, my lord, that may be done, my lord. But in the meantime.
You want only till then?
Till then.
All right.
Till, they will appear.
Taking time from the day of receiving summons, my lord. They can take another date, my lord.
No, my lord. They will appear, my lord, on the next date, my
They
lord.
want to appear, let them appear.
Yes, they will appear, my lord. In the meantime, they may be protected, my
They
lord.
protect protection, my lord, only.
If, my lord, at any time, my lord, their bail may be
They
cancelled.
may appear, my lord.
Learned counsel for the petitioner. It is for the trial court to see.
Yes, my lord.
Additional PP. You are appearing for informant. Learned additional, on perusal of the scanned copy of the TCR, it appears that the full statement of the victim recorded by the magistrate is missing. And so is the statement of the victim recorded by the police. Learned counsel for the petitioner submits that petitioner shall appear before the learned trial court and file appropriate application. Seeks some protection till then. Accordingly, of the observation that in the event, the observation that the petitioner shall appear before the learned trial court on the next date fixed, that is
5th of August, my lord.
of August, and in the event of filing any, the same shall be disposed of as per law till 5th of August or till the appearance of the petitioners, whichever is earlier. It is provided that they shall not be.
The next date of listing, my lord. Next, petition is disposed of.
Yes. What is that?
If, my lord, they appear, my lord, on the next date, my lord, and file petition, and learned trial court may be directed to release them on bail, my lord.
We passed the order after hearing your submissions as we understood them. We are not prepared to hear you any further.
But if,
Petition disposed of.
prepare petition, my lord, and if the
Better
petition is
think,
rejected,
before
my lord,
making your submissions, think
my lord,
what you are submitting.
my lord,
Don't make submissions first and then think what will happen.
if their petition is rejected, my lord, then
If
they-
their
they
petition
will
is
be-
rejected, they'll go to jail. Yes.
till their appearance, my lord, they are on bail, my lord.
Yes.
They appear, and their application will be rejected, my lord, and they will be put on behind the bar, my lord. My lord, my humble submission before your lordship, my lord, the learned trial court may
That
be.
was your submission, that you will appear, until then you may be protected. And accordingly, we have passed the order.
Till then, my lord, difficult, my lord, for them, my lord. So, my lord, my humble submission before your lordship, my lord.
Can't keep changing submissions after we pass the.
No, my lord, actually, my lord. I thought that the victim's statement is supposed to be called, my lord. And till then, my lord, they may be protected.
You said you will
submitted
appear.
my lord. If the petition is disposed of, my lord, so, my lord, kindly, my lord, that order may be passed, my lord.
Don't waste our time any further.
Please.
Wait, your lordship. This is appeal against my lord conviction. My lord petitioner was convicted, my lord. Section 4 of the POSCO Act, my lord, for 10 years. And presently he's in jail, my lord. The lordship kindly see the FIR, my lord, first, my lord. Because there is no paper book, so I have to read the evidence, my lord. Your lordship kindly, what, my lord?
Yes, go on.
No, the FIR was lodged on, my lord,
1/4/2019. The FIR, my lord, Lordship will find that there is a love affair, my lord, between the parties. And my lord, very interestingly, my lord, in this case, my lord, is a very classic example of, my lord, misuse of the POSCO Act, my lord. Here in this case, what happened exactly? The victim, my lord, she herself came to my house and forced me to marry her and entered my house. Then my mother informed the police that, and not only me informed the police, also parent of the girl victim, my lord. Then, my lord, police came and rescued her, and thereafter in the evening they lost the FIR. That they tried to force me, my lord, that I should marry her, and my lord, after evening, my lord, they lost the FIR that I have raped her, and accordingly, my lord, the case has been registered in the night, my lord, evening, my lord, and very next day, my lord, morning, he was medically examined, nothing was found, my lord. Now I'll just read the, my lord, PW one by one. There are 7 witnesses, my lord. 1 DW, 7 PWs, my lord. And PW 1 to 4, they are all relative, my lord. And others are 3, 5, 6, 7, sir, my lord, official witnesses, my lord. Your lordship, kindly take up, my lord, PW, evidence of PW 1, who is the victim, my lord. These all are in my English, my lord, and we need to translate, my lord. May I read the evidence of PW 1, my lord?
Yes.
My lord. The informant is my mother. The occurrence took place in the year 2019. On the day while I was going to ID Roy Ramada so-and-so higher secondary school, the accused pulled my hand and forcefully from the road and from the in front of his house and dragged me into the house, put my cloth and raped me. Then I made hue and cry. At that time, no one other persons was available in the house of the accused. Hearing my hue and cry, mother of the accused came, and then the accused fled away from the backside of the house. Thereafter, mother of the accused tried to drive me out from the house, but I refused to said act and of the accused. Then the mother of the accused called the police, and then police brought me to the house of my mother. House of my mother lodged the FIR against the accused, Shah Alam Sarkar. At the time of occurrence, I was student of class 9. Police sent to the SMCS Silchar, where my medical examination was done. Police brought me to the court, where my statement was under section 164 was recorded. Exhibit 1 is the statement of the exhibit 1 shows my signature. Police had also recorded my statement. At present, I reside in with my father. Cross. I was going alone to the school on that day. Only one girl of my area used to study in the said school, but she does not belongs to my classes. The house of the accused is adjacent to the PW road, and premises is open to is no boundary in the premises. There are another house in the backside of the house of the accused. There are another male, female member of the house, those house. In the house of the accused, his sister, mother reside, but none of available on the time of occurrence. It is not a fact that I have not shown any wearing apparel to the police. It is not a fact that the accused did not commit any rape upon me. It is not a fact that I have voluntarily entered in the house of the accused while the accused was not available in his house, for which the mother and sister of the accused tried to drive me out. I refused to came out from their house, and which they were compelled to take the help of my police. The father of the accused was serving and was living with the accused at the accused at Silchar, and the accused person and his family held newly settled in the thereafter the death of the father of the accused. There is a fact. It is not a fact that my mother had lost the false case and I had deposed falsely and collusion with my father. That is, my lord, PW1, my lord. Now PW1 is the, my lord, victim, my lord. PW2. He's the complainant, my lord, mother of the victim, my lord. I am the informant. I have lost this case against Shah Alam Laskar. The occurrence took place in the year 2019, the month of April. On that day, my victim daughter, who was at that time a student of class 9, went out from the house at 9 a.m. for the attending school. At about 2-3 p.m., police brought my victim daughter to my house. On being asked my daughter, I report me that
while she was going to the school, the accused dragged her to his house and committed rape upon her. Thereafter, keeping her at the veranda in his house, the accused fled away from there. I lodged a written FIR on the Kasudana PS against accused Sahalam Sokar. The said FIR was read over explained to me, and I put my signature upon the exhibit 2 is the FIR, where the exhibit 1 is my signature. Police sent my daughter to SMCH hospital where the medical examination was done. Brought her before the court where the statement of 164 CRPC was recorded. At the time of occurrence, the age of my victim daughter was 14 years and 8 months. Police had recorded my statement. It is not a fact that It is not a fact that I have not stated to the police that at about 2 p.m. police came to our house along with my daughter. It is not a fact that I have not stated the police that my daughter and told me that the accused raped her. It is not a fact that I have not mentioned in my FIR that the accused raped my daughter. I do not remember as to who was written the FIR, but the same was written at the police station. The house of the accused is at a distance about 200 to 250 meters from our house. There are other houses between our house and the house of the accused. People walk through the PW road adjacent to the house of the accused. There are other houses in the backside of the house and accused, and any noise can be heard from the road if made in the house of the accused. I do not know as whether mother of the accused receive any money or receive any benefit of the deceased husband. It is not a fact that in order to get hold of the said money, I made my daughter to go to the house of the accused and try to arrange marriage with him and with his motive to his false case I lost. It is not a fact. It is not known as to whether accused Shah Alam passed BA or not. It is not a fact that I have falsely deposed before the court today. It is not a fact that I accused did not committed any rape upon my daughter, the victim. That is now, my lord. Your lordship kindly say PW3, my lord. I know the informant and the accused person of the dog. The accused occurrence took place at 1.5 years back at about 9:30 a.m. At that time, the time of occurrence, I was at my home and hearing the halla, I accessed to the house of the accused Sahalam. I saw the victim girl standing in the veranda of the house of Sahalam. Then I asked the victim girl about her presence there, and she said that while she was going to her school, accused forcibly took her to the house. At the time of occurrence, the victim was student of class 9. Ramandulal Roy High School, and her age was 14 years. Police recovered the victim girl from the house of Sahalam as per order of the court. She was given to the Zimma of her father. The victim girl is the daughter of my own younger brother, namely Kamuruddin Borbhuya. Police recorded my statement. Many other girl student from the village goes to the Ramandullah Roy High School, crossing the house of the accused. Father of the accused was also not given, was got employed. He used to live in a Silsor along with the accused. The accused is a BA pass and his elder brother is a BCom pass. I do not know whether the victim girl returned back from home, the house of the accused 2-3 times earlier. I do not know whether police was informed by my mother of the accused. It is not a fact that I falsely stayed here. Hearing Hulla, I accessed to the house of the accused Sahalam. I saw the victim girl standing in the veranda of the house of the police Sahalam. Then I asked the victim girl about her presence there, and she said that while she was going to her school, accused forcibly took her to the house. That at the time of occurrence, the victim was a student of class 9 at the Ramadullah Roy High School, and her age was 14 years. The police recovered the victim girl from the house of the Shah Alam as per the order of the court. She was given to the Zimma of the father. That the victim girl is the daughter of my own younger brother, namely Kamaruddin Borbhuya. It is not a fact that I deposed falsely as tutored by the mother of the victim and the victim. PW4. I know the informant. I also know I know the accused who was present in the dock today. On the date of occurrence, I returned home from my work in the evening to my house. That mother of the victim girl told me that accused Shah Alam took away her victim daughter while she was either going to school or coming to her from her home from the school. Then the mother of the victim girl lodged the FIR with Kaswa Daram police station against the accused Shah Alam. Police recorded my statement, and later on the informant recovered her victim data as being handed by the police. Cross. I came to my home from my work at about 5 a.m. The victim is my niece to my brother. At 5 p.m. the victim girl was at her father's house. I, along with the victim girl and the informant, went to the police station. Other girls from my neighbors used to go to school along with the victim girl. It is not a fact that I did not state the police accused Shah Alam took away the victim daughter of the informant. It is not a fact that I did not state the police while she was either going to school or coming to school, coming from her school, the accused took her away. It is not a fact that I did not state to the police that the informant received her victim daughter as being handed over by the police. I cannot say whether the accused took away the victim girl. My examination in chief is hearsay. Now, my lord, PW5, my lord. I know the accused person in dock. I also know the informant. The accused took place about 2 years back at about 9 a.m. At the time of occurrence, the victim girl was going to school, and I found the victim girl along with others standing in the veranda of the house of the accused. After some time, police came here and took her to the father's house and handed over to her parent. Police recorded my statement. About 5-6 other girls used to accompany the victim girl toward the school. It is if any hue and cry or force is applied to any person, any people may gather. The veranda of the house of the accused is visible from the road and the road of the house of the accused and adjacent to the PW road. Mother of the accused called on the police to send the victim from the house of the accused on her parental house. It is not a fact that I did not see the victim girl in veranda of the house of the accused. Further, the victim girl is my parental cousin brother. It is not a fact that I deposed falsely today at the behalf of the cousin brother. Now, PW6, my lord. Doctor, my lord, who examined the, my lord, victim girl, is very important, my lord. On 2/4/2019, I was posted as a GM DMO Department of the Forensic Medicine of Silchar Medical College. On that day, on the police requisition, I examined the individual named Masuma Begum Borbhuya, daughter of Komaruddin Borbhuya, so-and-so, district so-and-so. She stayed at the home, religion Muslim so-and-so. Age as told by the individual 14 years 8 months. History as per the survey on 1/4/2019 around 9 a.m. the morning on way of the school, she was forcefully pulled to by the boy some named Shah Alam to his house, had forcefully sexual intercourse with her and fled away, keeping in his own veranda. Then the police brought her back home. She took bath and changed her clothes. On physical examination, identification mark, bound mole under so-and-so, height so-and-so, the abdominal guard and normal so-and-so, general build and appearance, the thin build, voice, female, child, teeth 7 in all 4 quarters, hair, axillary so-and-so, not present, breast impression so-and-so, belonging in nipple and venter, puberty as told by the individual attained at the age of 12 of age, menstruation as told by the individual 5 days regular cycle, LMP also told the individual 5 days back, mental condition normal, grind normal, intelligence average, wearing garment any suspect stains present, nil, body injury nil, general examination public hair present non-matted, vulva, labia majora and minora healthy, hymen wide open, vagina healthy, cervix and atmos healthy, foretex and perineum healthy, vaginal swab taken from the posterior position, no spermatozoa or gonosis under the microscopic examination. Result of X-ray investigation plated so-and-so, wrist joint, emphasis is lower of the radius and appeared but not fused with the parent bonds, elbow joint, so and so, with the so and so. Emphasis of the head of the human.
Right, we have gone through that part.
My lord, no, my lord, your lordship can see on opinion part, my lord. Opinion part has a lordship body.
Yes, we've got it.
My lord, yes, your lordship kindly see what IO's first duty of the IO to, my lord, in a POSCO case, my lord, to collect the age of the girl, my lord, because she's a student, my lord. She's a student, my lord. So it is well recorded, my lord. They knows it very well. Because I collect that birth certificate, but very unfortunately that was not been exhibited anywhere. Although I have annexed here, there is, my lord, no value is there. My lord, what happened in this case, my lord? Here in this case, your lordship kindly see that girl, my lord, who stated, your lordship kindly see the 164 statement, my lord, very important, is the exhibit, my lord, of the girl, my lord. She said that I was raped, I was bleeding, I was forcefully done, but here, my lord, your lordship kindly see what they are found by the doctors, my lord. Absolutely nothing, my lord. Now, my lord, very important, I will come to the IO, my lord.
Yes.
PW7. PW7 is the IO, my lord. Very important, my lord. On 1/4/2019, while I was posted at a Kaswadram PS on Sensor that I received an Azahar lost by one Nurahar Borbhuya and registered by Kaswadama PS case number 59 of 2019 under 365/506 IPC duties section 4 of the POSCO Act and took myself to the investigation of the case. During the investigation of the case, I visited the place of occurrence, draw up the sketch map of the place of occurrence under objection, recovered the victim girl from in front of the house of the accused at Dokhin Mohapur part 5 PS Kaswadonga. Thereafter, I produced the victim girl to the Silsor court, where the statement was recorded by the magistrate on 164 CIPC. As per order of the court, the victim girl was kept in Ujala home on 24/2019. The victim girl was also sent to Silsor Medical College, Silsor, where she was medically examined. I examined the victim girl, Kaswadama place, where she was brought by her family member. I examined her other witnesses also. I have collected the medical report from CSMSCS Silsor. Accused surrender in the court. As per order of the court, the victim girl was given to Zimma to her father. Later on completion of the investigation, I have submitted the charge sheet against the accused person. So and so is the charge sheet so and so. Cross-examination by the defense. The statement of the victim girl was not recorded by any female police officer. I did not recover the victim girl in front of the house of the accused at Dokhin Mohanpur part 5 PS Kaswanunga, but she was produced before the police station by the parent and other relatives. I have not mentioned the fact that the victim was produced by the parent and other relative of the fact or the fact as to how the recovered the victim or the forwarding report was forwarding the victim to the court for recording the statement. I have not submitted any sketch map with the charge sheet. It is not a fact that the exhibit 3 is the carbon copy. The content of the exhibit 3 is the written by another person. I merely sign it. The map in exhibit 3 was drawn by another person. As per exhibit 3, the place of occurrence is road. In the exhibit 3 is the house of Nurul Haq Laskar, Bilaluddin Laskar and Islam Ali are also shown. I have not examined Nurul Haq Laskar, Bilaluddin Laskar, Ismail Ali, their family member. It is not a fact that I have never visited the place of occurrence, as the exhibit 3 was prepared and written by another person. It is not a fact that I have prepared the exhibit 3 in connivance with the informant. It is not a fact that I record the statement of all the seated witness by sitting in the police station on the same day. I received the FIR at 6:30 p.m. after sunset, and exhibit 3 time of preparation of the same is not mentioned. There is no documentary proof as to the fact of recovery of the victim along with time of recovery. It is not a fact that the victim voluntarily went to the residence of the accused Shah Alam and the mother of the accused tried to send her back, but failed and accordingly she lodged the informant with me, and that upon receipt of the information, I went to the police place of occurrence. I took victim to the parental residence, but her parent refused to accept her, and as such, I was bound to take her to the police station. And in the evening, then in connivance with some vested interest person, and I and the parent of the victim, the FIR was lodged on the some false allegation, and the case was registered. I have not recorded the statement of mother of the accused, sister and the accused, and the father of the victim. PW2 did not state before me that about 2 p.m. police came to their house along with her daughter. She did not state before me that her daughter told her the accused had raped her. PW4 did not state to me that Shah Alam took away the victim, daughter of the informant. This witness also did not state to me that while she was either going to school or coming from home school, accused took her away. He also did not state to me that the informant recovered the victim daughter as being handed over by the police. It is not a fact that I never visited the case, investigate the case by following the prescribed procedure of law. So, my lord, there is one DW also, my lord. Very important, my lord, your lordship. I
have gone through that also.
My lord. So, your lordship kindly see here, first thing, my lord, that was not done by the police, my lord. IO has not investigated regarding age, my lord. It is very easy to him, my lord, to collect the that birth certificate from the school or any certificate from the school. That was not done. Only, my lord, evidence of the doctor. On the basis of that, my lord, your lordship kindly see in chief, my lord, the doctor says the age as told by the victim, and ossification test says it is 16 to 18. Oh, sorry, my lord, 14 to 16. So, my lord, only basis of that, my lord, age is determined, which is not permissible under the law, my lord. There is a very recent judgment passed by your lordship also. I'll place, my lord. My lord, as per, my lord, regarding, my lord, determination of age, my lord, that it has to follow the JJ Act, my lord. Now, JJ Act, there are three, my lord, procedure, my prescribed. One, that is, my lord, birth certificate issued by the school competent authority. But a certificate issued by the metropolitan, my lord, any municipal board, anything, my lord. And third, there is a medical board. But that is not done here, my lord. And, my lord, only on the basis, your lordship kindly see that the JJ Act, my lord, section 96, my lord. Section 94, my lord. Presumption and determination of age, my lord. In 94(2), in case of the committee or board has a reasonable ground to doubt regarding the whether the person brought before the child or not committed the board so and so, the determination of checking the evidence of the obtaining the date of birth certificate of the school, the matriculation or equivalent certificate from the concerned examination board, if available. If not available, then, my lord, the birth certificate given by the corporation or municipal authority, and only in the absence of 1 and 2 above age shall be determined by a sufficient test or other test, medical age determined by the conduct of the other committee or board. That has to be, my lord, not by the doctor, my lord. There is a board, my lord. So that is not been followed here, my lord. Now, my lord, your lordship kindly see that only, my lord, statement of the victim, my lord. Statement of the victim, my lord, 164 statement that clearly stated that there's a bleeding and I was forcefully done it, my lord. And if your lordship go by the, my lord, evidence of the, my lord, medical officer, my lord, there is no sign, there is nothing, my lord. So then how can I trust, my lord, that girl, my lord? How this court can trust that girl, my lord? So he is not trustworthy, my lord. If it is trustworthy, then also, my lord, it can be, my lord, acted upon, my lord. And, my lord, so far as DW is concerned, my lord, she has clearly stated that my son was not even there in that day. He went to the, my lord, Pune, that, my lord, even, my lord, plane ticket was also exhibited, my lord. And that evidence was totally overlooked by the trial court, my lord. Because
Trial court said that there is no boarding pass, only ticket will not
no,
prove.
no boarding pass return. No boarding pass return. Returning journey, no boarding pass. So that's why. Now that, my lord, probably nowadays, my lord, in case of, my lord,
No, no, there
e-boarding,
was no ticket for the return journey. It was ticket
that
was
is the
only
finding
for
of the
the
learned,
one way.
my lord.
And in that case, court has held that only the boarding pass will prove that he has left.
My lord.
And even otherwise, he left on 27th, occurrence took place on 2nd, so he
Second.
could have come back in between after that.
That, my lord, your lordship kindly see, my lord, there is another view is possible, my lord. Your lordship, why I am submitting that the girl, your lord, that suppose I have committed a crime, then why I should inform the police, my lord? That is a common sense, common, my lord, view of the human behavior, my lord. And, my lord, the girl was refused to take back by her own mother, my lord. And very first line of the, my lord, 164, when she has a love affair with the boys, my lord. That was before magistrate, my lord, and very next day, my lord. I have a love affair since last 1 year. So, my lord, under this circumstance, my lord, your lordship kindly said that DW is, my lord, very important, my lord. So, and more regarding, my lord, ossification test, that cannot be a conclusive proof, my lord. That judgment, my lord, I just, there is a division bench judgment of the Ava High Court also. And your lordship, my lord, judgment, my lord, I done. That's criminal appeal number 110 of 2023, my lord. Farooq Islam versus State of Assam.
Age may save you from POCSO, but not from 376.
No, my lord,
Age fact,
your
only
lordship
age.
kindly see 376, my lord, that, my lord, I will come to that medical evidence, my lord, because your lordship kindly, section 4 was inserted here, my lord. Section 4, my lord. Because section 4, my lord, medical evidence totally, my lord, against the, that is not corroborated by evidence of the PW1, my lord.
I am only saying about age. Suppose age is found to be above 18.
My lord.
That will save you from POCSO. But other things will have to be considered for 376.
And, my lord, your lordship, you have to see the, my lord, medical evidence, my lord.
Yes, of course. All the evidence, why only medical?
Not only, my lord, yes, all the evidence, my lord. So in that case, my lord, 376, my lord, prosecution has to establish the case, my lord. Because initial burden, my lord, section 29, to, my lord, they have to, my lord, decide the burden, my lord.
In that case, they cannot take resort to section 29 of the POCSO Act to
My lord.
make the presumption.
Presumption, my lord.
It will be like a normal
My lord.
trial.
My lord. So, my lord, regarding, my lord, task 30, my lord, I want to place, my lord, one judgment of the very recent judgment of the Supreme Court, my lord. Para 15, my lord.
I think we'll have to continue on another day because we have to leave for Judicial Academy.
My lord. Keep it part hard, my lord.
Yes, heard in part. List again on. Give a date. Let it be next week itself. Yes. Things will be fresh then. Lot of time pass, then we have to again. Next week, there is
6, no, 6. Deep look.